All right, we're going to go ahead and get started here. I'm going to give the IT folks a heads up so they can start their recordings. And we're good. All right. Good morning. As I mentioned, we are waiting for one council member, so we'll acknowledge when she gets here, but we do have a quorum. So we'll start off with our Bagley-Keene requirement to conduct a roll call of the council members to establish that quorum. And I'll ask Emma to lead us in the roll call for our council members. Emma?
Councilmember Burgess.
Here.
Councilmember Damrell. Councilmember Weso.
Here.
Councilmember Moranian.
Here.
I'm going to note that Vice Chair Miller is absent. Councilmember Zingali.
Here.
Chair Lee.
Here.
We have a quorum.
Thank you. So good morning, everyone, and welcome. I'm Julie Lee, the chair of the Delta Stewardship Council, and we are here today for the public hearing on the appeals of the certification of consistency for the 2024 through 2026 Proposed Geotechnical Studies project, which for convenience can be referred to throughout this hearing as the Geotech project. Let the record reflect that it is 9:36 on Thursday, December 19th, 2024. This hearing is being conducted in person here in room 221 at 715 P Street in the California Natural Resources Building located at 715 P Street in Sacramento, California, and remotely via Zoom. Next, Emma is going to explain how the public can participate in this meeting. Emma?
All right. Anyone who would like to provide oral public comment during the public comment period for the hearing, which will follow the conclusion of the presentations, needs to fill out and turn in a blue card to the council clerk or contact the council clerk via email at engage@deltacouncil.ca.gov or by telephone at 916-275-6824. And provide a name and or organization if applicable. If you are a tribal representative or elected official speaking in an official capacity, please indicate this in the space provided. For attendees via Zoom, please use the raised hand feature on Zoom. Public commenters will be called by the council clerk to speak in the order the requests are received. Attendees on Zoom will be called on by the council clerk and unmuted to speak. Any written public comments received later than noon, the day before the meeting, will be delivered to council members after the meeting.
Thanks, Emma. Today, we're going to have a staff presentation followed by presentations from the party to the appeal. The appellants will be heard first in the following order: San Francisco Baykeepers et al., South Delta Water Agency, County of Sacramento et al., and San Joaquin County et al. After the last appellant, we will hear a presentation from the Delta Protection Commission, and then the last presentation will be given by the respondent, the Department of Water Resources. We're going to take a 10-minute break before the presentation from DWR and a 1-hour lunch break around 12:30. The Delta Protection Commission and each appellant will each have 15 minutes for their presentations. Pursuant to the council's appeal procedures, the certifying agency is afforded the combined amount of presentation time that is afforded to the appellants. Accordingly, DWR will be allowed an amount of time equal to the 4 appellant presentations combined for a total of 60 minutes for their presentation. I'm now going to ask the council's Deputy Executive Officer for Planning and Performance, Jeff Henderson, to provide a brief staff report for this item. Go ahead, Jeff.
Chair Lee, before you
Yes,
start,
ma'am.
I have a presentation. I have is this where I should be making my comment or should I be waiting?
Sure.
Okay, all right, thank you.
Thanks, Diane.
Great, thank you. And maybe we have the PowerPoint for the staff presentation, please. All right, good morning, Chair Lee and council members. I'm Jeff Henderson, Deputy Executive Officer for Planning at the Council. And we're here today for the public hearing on appeals of the Department of Water Resources certification of consistency for the 2024 to 2026 Proposed Geotechnical Activities project. Next slide. I'll present briefly regarding the Council's covered action authority under the Delta Reform Act and the Council's regulations. We'll provide a brief description of the project submitted by the department and the role of the Delta Protection Commission in these proceedings, and overview the certification and appeals process to date. After that, we'll proceed with today's hearing. Next slide, please. The Council's covered actions authority sources from the 2009 Delta Reform Act, which established the co-equal goals of providing a more reliable water supply for California and protecting, restoring, and enhancing the Delta ecosystem. The co-equal goals shall be achieved in a manner that protects and enhances the unique cultural, recreational, natural resource, and agricultural values of the Delta as an evolving place. The Reform Act charges the Council to develop and implement the Delta Plan, a comprehensive resource management plan for the Sacramento-San Joaquin Delta and Suisun Marsh. As part of this charge, the Council has regulatory and appellate authority over certain state and local public agency plans, programs, and projects in the Delta and Marsh to ensure they're consistent with the Delta Plan. These actions are known as covered actions. The Delta Plan includes 17 regulatory policies adopted to meet objectives the legislature said in statute were inherent in the co-equal goals. And a state or local public agency carrying out, approving, or funding a covered action in the Delta must demonstrate a covered action's consistency with the Delta Plan regulatory policies prior to implementation of the action. Next slide, please. Agencies demonstrate consistency with the Delta Plan by submitting to the Council a written certification of consistency with detailed findings as to whether its covered action is consistent with the Delta Plan. Any person who claims that a proposed covered action is inconsistent with the Delta Plan, and as a result of that inconsistency, the action would have a significant adverse impact on the achievement of one or both of the co-equal goals or implementation of government-sponsored flood control programs to reduce risks to people and property in the Delta, that person may appeal the certification of consistency no later than 30 days after the submission. The appeal must include specific factual allegations. The Council must hold a hearing on the appeal within 60 days of the date of the filing, unless it's determined that the issue raised on appeal is not within the Council's jurisdiction or does not raise an appealable issue. We're gathered today for such a hearing. Both written certifications and appeals are typically submitted online on the Council's website, along with the supporting documents, notices, and public comments received. Next slide, please. In reviewing the certification and the appeals, the Council applies what is known as the substantial evidence standard of review. And under that standard, the Council does not independently review the covered action to determine if it's consistent with the Delta Plan. However, the Council does make a determination based on whether the certification of consistency is supported by substantial evidence in the record before the public agency that filed the certification. And importantly, the appellants have the burden to show that the certification of consistency is not supported by substantial evidence in the record. Next slide, please. So a bit about the proposed geotechnical activities under consideration today. The certification states that the proposed geotechnical activities are intended to support the planning and design of the Delta Conveyance Project, and that they would be located in Sacramento, San Joaquin, Contra Costa, and Alameda counties from north of Hood to the Bethany Reservoir. The certification describes that the activities are proposed to collect valuable data to refine the Delta Conveyance Project's alignment and the project's design. The activities would consist of soil borings, cone penetration tests, and water quality tests. These investigations are expected to yield important data about soil properties and water quality. Next slide, please. That data in turn will inform the planning and design of the Delta Conveyance Project. Continued planning and design efforts will assist the department in identifying and applying the applicable provisions of the Delta Plan when submitting a certification of consistency for the future implementation of the Delta Conveyance Project. In the certification, DWR states that it did not originally plan to submit a certification of consistency for these activities. The department does not understand the activities to constitute initiating the implementation of the Delta Conveyance Project. Rather, the department understands the activities to be preliminary investigations related to the Delta Conveyance Project's planning and design, which the department understands to be separate from the Delta Conveyance Project's implementation. Next slide, please. The department filed a certification of consistency for the geotechnical activities on October 8th, 2024. In that certification, the department found that all 17 Delta Plan policies do not apply to the geotechnical activities. You'll hear more from representatives of the department today regarding those findings. Next slide, please. The council then received 4 timely appeals on November 7th, 2024 from the following parties: San Francisco Baykeeper, Winnemem Wintu, Shingle Springs Band of Miwok Indians, California Indian Environmental Alliance, Friends of the River, Center for Biological Diversity, Save California Salmon, California Sport Fishing Protection Alliance, Golden State Salmon Association, and Restore the Delta, an appellant group to be referred to as San Francisco Baykeeper et al. South Delta Water Agency, or SDWA, the County of Sacramento, Sacramento County Water Agency, Sacramento Area Sewer District, and the City of Stockton, a group referred to as County of Sacramento et al., and County of San Joaquin, Central Delta Water Agency, and local agencies of the North Delta, or San Joaquin County et al. You will hear today from each of the appellants during today's hearing regarding their appeals. Next slide. So this slide and the following slide indicate essentially by appellant which policies were appealed. So if there's an X in the box, that means that that particular appellant party appealed that particular Delta Plan regulation. And the 17 regulations are listed on this slide. And next slide, please. And the following slide. Next slide, please. So the Delta Protection Commission has a role in the appeals process. And that role is that the commission may provide a written submission on issues raised in the appeals according to the schedule provided in the notice of hearing and schedule of written submissions issued during the appeal process. The commission also has an opportunity to present at the hearing on issues raised in the appeals, and we anticipate that the commission will do so today. The council considers the comments and presentations submitted by the commission regarding issues raised by an appellant as those of an expert in matters that may affect the unique cultural, recreational, and agricultural values of the Delta. Next slide, please. So we'll close by summarizing our relevant timeline and potential next steps. And again, on October 8th, 2024, the Department of Water Resources filed a certification of consistency for the present matter. On November 7th, 2024, 4 appeals were filed on this matter. Today's hearing is within the window of the first 60 days following the filing of the appeals, and the council must issue a decision within 60 days of today's hearing. After today's hearing, staff may be directed to prepare a draft determination for the council's consideration within 60 days of the hearing. Madam Chair, that concludes the staff presentation. Thank you.
Thanks, Jeff. We're now going to move on to hear the parties' presentations, and to those representing the California Department of Water Resources, the Delta Protection Commission, and the appellants here today who will present on the geotech project appeals, please listen closely to the following instructions. This entire hearing is being recorded by a certified court reporter. If you're interested in purchasing final transcripts from the reporters, please work with them directly. The company name is California Reporting LLC. Their telephone number is 510-313-0610. I'd ask you to please speak clearly so the court reporter can accurately transcribe these proceedings. As with all public council meetings, this hearing will be broadcast and archived via Admin Monitor, which you can find online at california.adminmonitor.com/Delta, where the audio and video recordings will be available for later review. Council members, I'll ask you to hold questions until the conclusion of each party's presentation. And at that point, I will open the opportunity for council member questions before proceeding on to the next party. Before we begin with opening presentations, Councilmember Burgess would like to make a brief statement.
Thank you, Madam Chair, and good morning to everybody. Welcome. To my fellow members and Madam Chair, and to the parties and the public, I have an announcement I'd like to make. My seat on the council is unique among the members. I sit on the council because I am the chair of the Delta Protection Commission, and as a result, have a seat on this council pursuant to the Delta Reform Act. The Delta Protection Commission has an interest in these proceedings. The commission has an advisory role to play pursuant to the council's regulations. And as a result, the commission has sent communications to this body about the proceedings and will present before the council today. In order to judge these proceedings fairly, to honor the ex parte communications prohibition, and to avoid even the appearance of them, of bias, I've taken the following precautions. I've created an ethical wall separating myself from any Delta Protection Commission activities and communications relating to the 2024-26 proposed geotechnical activities once we went under ex parte prohibition on November 7th. For example, before the commission deliberates matters relating to the proposed geotechnical activities, I recuse myself and leave the room. I take no briefings from commission staff on the proposed geotechnical activity matters, and I had no role in drafting, reviewing, or authorizing any commission correspondence to the council or anyone related to these proceedings. And as a result, though it may not be clear from the commission's letterhead on the communications to this body, I'm not a signatory to any of the documents related to this matter from the commission and have not been since we went under ex parte communication restrictions on November 7th. I take my participation as impartial adjudicator in this matter very seriously. I feel that it is important to state this for the record, not only for these proceedings, but for all future proceedings we will have on this matter. I look forward to a fair, impartial process for all parties and participants. Thank you.
Thank you, Councilmember Burgess. We'll now begin with opening presentations. When you are called upon to speak, please state your name and identify the party you represent for the record. If more than one person is presenting, please remember to state your name when you start speaking so the court reporter can note the speaker for the record. I'll ask for our first appellants, San Francisco Baykeepers et al., to be seated. As a reminder, you have 15 minutes and there is a timer, so you'll be aware of when you need to conclude. Welcome.
Good morning. Thank you for having me. Good morning to the commission members. My name is Eric Busher. I'm the managing attorney at San Francisco Baykeeper, and I'm here to present today on behalf of the appellants that Mr. Henderson identified, the Winnem and Wintu Tribe, the Shingle Springs Band of Miwok Indians, California Indian Environmental Alliance, Friends of the River, Center for Biological Diversity, Save California Salmon, the California Sport Fishing Protection Alliance, Golden State Salmon Association, Restore the Delta, and Baykeeper. Many of the representatives from those organizations are observing or participating in the Zoom hearing today. If we could have our presentation on the screen, thank you very much. And the next slide, please. DWR's consistency determination that has been submitted here is arbitrary and illogical, and it is fundamentally inconsistent with the Delta Reform Act. The actual covered action, the actual project, the new tunnel or the Delta Conveyance Project is not analyzed. And that is the relevant conduct and consideration under the law and for the people who care about the Delta and the future of California's water policy and water resource choices to be made aware of, to understand, and to determine. What we have here today is a portion of that project. Next slide, please. I want to start where I think this matter begins and ends. And it was absent from staff's description of the appeals process and the considerations here today. The first question is whether what the Department of Water Resources has proposed is a covered action or not. And the Delta Reform Act, passed in 2009, made clear that a covered action is a plan, a program, or a project as defined pursuant to section 21065 of the Public Resources Code that occurs in the Delta and has the potential to have a significant impact on one or both of the co-equal goals. In turn, CEQA, the California Environmental Quality Act, defines a project as an activity which may cause a direct physical change in the environment. And for 5 decades before the Delta Reform Act was passed, it was well judicially and regulatorily understood that a project under CEQA is the whole of an action. It's not a slice of it, it's not a segment of it, it's the entire thing. And what is clear from the Delta Reform Act is that those two things, the covered action and the project, are equal and the same. Next slide, please. Today, we have before us a covered action that is described by DWR as 261 boring holes, 15 CPTs, and 31 water quality tests at some of those boring hole locations. When you look at how DWR defined the project, it is a proposed 6,000 cubic foot per second diversion capacity alternative. It consists of the construction, operation, and maintenance of new diversion and conveyance facilities and a tunnel that will travel almost 45 miles from north of the Delta to south of the Delta. Those two things are not remotely the same. You ask any attorney, any member of the community in the Delta, any engineer, are 260 holes in the ground the same thing as a 45-mile underground tunnel to extract water from the Delta? And the answer you will get is of course not. And the department does not disagree with that conclusion. But that is where this matter should end. What we have before us is not, as a covered action, is not the project. And what we have before us as a covered action, approving that would be inconsistent with the Delta Reform Act. Next slide, please. Now, use of a different covered action and project beyond being illegal, beyond being where this inquiry should end, also has consequences for how the DWR has asked this council to evaluate the current situation. So first, and the delta between those things, I think, demonstrates the flaw in, or the fatal flaw in DWR's decision. But first, on the left side of the screen in the top half is DWR's response to the covered action checklist that the council created. And I apologize, it's small. I wanted the whole paragraph there. We got a limited number of slides. But in short, at step 2, question 4, the council asks, will this have an impact on the co-equal goals? And DWR says in response, the geotech activities would have no impact on the achievement of one or both of the co-equal goals or on the implementation of a government-sponsored flood control program. Now, according to the council and the covered action checklist, which is the next picture here on the left, if you say no to any of the questions in step 2, stop, no further steps are required, it is not a covered action. Right? So beyond the plain statutory requirement here, the council has made clear, if you do not have an impact, it's not a covered action. The department says no potential for any impact at all. That should have been the end of the department's work and our work. Instead, the department decides to pretend it is a covered action, despite the council's clear guidance and the statute's clear mandate. But the geotechnical work are a part of a covered action. And again, that should end the review. But the illogic continues. DWR then tries to take what it is pretending is a covered action and apply the policies to those activities. And as you saw during Mr. Henderson's presentation, 18 times the department says simply not applicable. When you add up not applicable plus not applicable plus not applicable continued, you get to the inevitable and unavoidable conclusion that what you have before you was not a covered action in the first place because it's not applicable to any of these policies and objectives. Instead, DWR adds up 18 not applicables and says consistency. That defies rational decision-making, it defies logic, and it defies evidence. Next slide, please. Oh. I think we need to go back to page 6. Sorry. The last thing I'll note on, should be one forward. Okay. Well, the last thing I'll note here, I'm not sure what happened with the slides. The third problem and fatal flaw with DWR's separation of a covered action from a project is that the approach is entirely arbitrary. DWR identifies in Chapter 3 of the final environmental impact report for the tunnel a whole host of geotechnical activities. Those aren't analyzed here, only a slice of them. Why only through 2026? Why 261 boring holes? Why the locations that they identified? Why none of the trenching work that they say is necessary in the final EIR to understand and design the project? Is that not included here? There is no analysis in the department's consistency determination of the impacts of operations. There is no analysis of the impacts on environmental justice communities and tribes. There is no analysis on the impacts of operations on the ecosystem of the Delta. And those arbitrary choices, in addition to being fatal to the department's consistency determination, have real consequences were the council to accept them. Once the council goes down the road of allowing people to ignore the advice of what constitutes a covered action, to pick and choose and slice ever thinner segments of a covered action or a project for consistency determination reviews, every single applicant expects that same special treatment of its own arbitrary choices. And approving the arbitrary choices of the applicants and giving that special deference to some, but not others, risks the council's credibility and its ability to achieve its mandates to protect the Delta in the future. We go to the next slide, please. I want to make just a couple of notes on what else is missing from the consistency determination. First, there's no evidence or analysis of the impacts on the tribes and the EJ communities. As the council recognized in September in the draft environmental justice and tribal report that it published, and at the comments on that hearing, during that hearing, there is a need to include these people, their interests, their rights in policy decisions before this council in the future. There's a need for applicants to consider and analyze the impacts on the rights and interests of tribes and environmental justice communities. And I would ask that the council follow its own recommendations and those of the people who assisted it in preparing that report, the tribes and those community members, to take the steps that it deemed necessary and update those policies before we're back for an actual review of a consistency of the Delta Conveyance Project, which is likely to be the biggest infrastructure project that this council makes a determination about. That needs to be a complete, inclusive, and updated process. Next slide, please. The other thing I will note, the Delta is a place and the council treats it as such, but it's a lot more than that for the communities who live here now and for the Native people who were here for time immemorial before us. The Delta is not just a place defined by specific geographic boundaries for them. It is a tribal cultural landscape. It is itself a dynamic tribal cultural resource. And within the Delta, there are also specific tribal cultural resources known to exist in and around the locations that DWR intends to do the geotech work. And what history tells us is that the mitigation measures that DWR has used in the past to avoid irreparable harm to those buried tribal cultural resources are ineffective, do not adequately include or consult with the tribes, and are no guarantee that those irreparable consequences will be avoided. Next slide, please. This was the one about why DWR's choices are arbitrary. I apologize, we got out of order. Next slide, please. So I'll make one more point before I conclude. The record in this case, or in this action before the council, it is both over-inclusive in that it includes portions of the final EIR describing impacts of the Delta Conveyance Project that are not at all before the council, and under-inclusive in that it does not include the years of back and forth between council and DWR that led to the consistency determination here. The council, staff, and DWR have engaged in early consultation, and whatever the council recommended to DWR or told DWR in that process, and DWR's response should be before the public and the council in making this determination. And there is no way that the council or its staff, through early consultation or otherwise, can change the legal requirements of the Delta Reform Act and the requirement that we consider the whole of a project when we analyze a covered action. I will note, approving the consistency determination is unlawful, it's arbitrary, it lacks evidentiary support or any rational decision-making processes, and we would ask that you grant the appeals that have been filed here, remand this matter to the Department of Water Resources with instructions to evaluate the entire covered action, and that while that remand occurs, the council update its own processes, its own policies, its own standards as it did, as the recommendations in the Tribal and Environmental Justice Report requested. I see I've got about a minute and a half left. I'd like to reserve a little bit of time to respond to DWR, and I'm happy to answer any questions that any of the council members have.
I thank you very much, and thanks for staying within the timelines. First, I'll turn to the members and see if we have any questions, and I see that Dan Zingali online has his hand up. So Council Member Zingali, we'll start with you.
Thank you, Madam Chair, and thank you for the testimony. The issue of the impact on environmental justice communities and tribes is one that is of great interest to many of us on the council. I'm just curious if you can identify any legal requirement for an analysis of the impact on the environmental justice communities or tribes. My understanding is there is not currently. Is that true?
So I don't think that the Delta Plan as currently drafted explicitly calls out the interests of environmental justice communities or tribes. Right? That was one of the things that the council's report from September identified as was lacking, right? There was a lack of any consideration of tribal rights. I will say, council member, the fact that the statutory text does not call it out does not mean that the state, the state of California, local agencies, et cetera, do not have obligations to those communities and those tribes. But I agree it is absent from the current version of the policies and objectives of the Delta Plan. And that's one of the things we think is vitally important that the council update before a full consistency determination for the actual Delta Conveyance Project. We also think it's a flaw inherent in approving this application without being able to gather that input and consider those rights and interests.
Thank you very much.
Thank you. Yes, Councilmember Burgess.
Hello, Mr. Busher. You said something, and I wanted to clarify what you were saying. You said a project under CEQA is. Can you go back to that? What you were saying, because I wanted to really be clear on what you were trying to say.
Yeah. So I think the fundamental point is that a covered action and a project are one and the same thing as the Delta Reform Act was adopted. And I think the clearest way to understand this, I mean, the legislature could have said, right, we're enacting a new statute to account for the Delta as a place to try to achieve these co-equal goals. How do we want to figure out how to determine who needs to come to the Delta Stewardship Council and who does not? And they looked around and they said, we've got 50 years of CEQA. that's a statute about analyzing the impacts of projects, right? Infrastructure projects, long-term operations, et cetera. But big scale, large scale, small scale things, and said, that works. People know what that is. It makes sense. We're going to use that definition. And they could have said, just use the word project and probably accomplish that goal. But they went one step further and said, a project as defined in 21065 of the Public Resources Code, which is the citation to CEQA. And once the legislature made that decision, right? Everybody knew in 2009 that a project under CEQA was the whole of an action, right? Courts had said that, the California Supreme Court had said that, the CEQA regulations had said that. That's what everybody understood projects to mean under CEQA. And so when the legislature says a covered action is a CEQA project that occurs in the Delta and will impact the co-equal goals, clear as day that those two things are identical under the law, and clear as day that they are diametrically different here.
Okay, and so then in your presentation, I think you were saying that you don't believe this is a covered action. Am I misunderstanding?
So,
Because I think my understanding is DWR didn't think it was a covered action, but legally we're forced to address it by the court. So I'm just trying to understand, because I think you said something that they pretended that it was a covered action, and I just want to make sure we're all on the same page.
yeah, so let me try and answer that in two ways, right? Number one, I don't think it is the covered action, given that we have a definition of the project, and that those two things, right? The project is a 6,000 CFS tunnel for 45 miles. The covered action is 270 holes in the ground, right? Those are not the same. And because we have defined, because the department has defined what the project is, right? The department is stuck with that same definition for the covered action.
Okay.
The second thing I'll say is when the department went through and walked through the covered action checklist, what it said was, this will have no impact on the co-equal goals. And what the checklist says is, if that's your answer, it's not a covered action.
Right.
So they decided to move forward, and I want to briefly disagree. The court did not tell them to do this in any way, shape, or form. And Ms. Lacey will speak more to this in a little while. But what the court told them was, you have to stop implementing what you have described as the project until you have a consistency. Say, go apply for a consistency determination for a slice of the project that's not actually a covered action. That's not at all what the court said. That was DWR's choice.
Thank you, Mr. Bushy.
Thank you.
So I think it's important. Oh, sorry, Ben, you go ahead. Councilmember Hueso.
So I'm trying to understand your objection. If this, if it's found that the borings are consistent, do you see that as an approval of the overall 45-mile tunnel project?
I would certainly hope not. Not at all. That's
So
not what's
you don't
before.
you don't believe that's what's before us?
Correct. What DWR has put before the council is very much not the 45-mile project, right?
And
They
it's-
have said
It's simply borings,
it is the geotech activities, correct?
and they're arguing that they are consistent with the Delta plan.
That is their position. I think fundamentally the problem with their position is that you can't do a consistency determination for a thing that's not a covered action.
And at the end of the day, if the project is never built and the borings are taken and the data is gathered, is that data valuable in learning more about the Delta and the soil, and can that data potentially yield information that would be beneficial to understanding the Delta?
I am very skeptical that the specific things that DWR has sliced off from the project to perform as the proposed geotech work will have any sort of systematic benefit for anything other than the Delta Conveyance project and for the Delta as a whole, especially if that does not move forward. the tunnel does not move forward, right, that learning about those 260 locations is going to be representative or helpful. I also think that's not the purpose for which DWR is proposing to do this, right? They're proposing to do this because they think it is a step toward building the tunnel, right? Not because they want to gather information for the benefit of the communities in the Delta. And I think if the council wanted to have a better understanding of the geology of the Delta, the seismology of the Delta, the water quality of the Delta, the soils of the Delta, right? Randomly selecting 260 holes that DWR picked is not the way to go about that, right? The way to go about that is to do a systematic analysis of those things and to understand what are the benefits, what can I learn, and to do that intentionally with a goal of learning new useful information rather than just adopting the department's goal of we want to build the tunnel.
And have you found any specific Native American resources that will be harmed by the borings?
So there is not a systematic survey of the location of all of the specific archaeological sites or historical sites or burial grounds. There are some known locations that my understanding is that tribes have tried to share that information confidentially with the Department of Water Resources. It is not something that they are required to or like to make public as to where these sacred sites are located. There have been, and this is described in the 3 declarations that we submitted along with our brief on November 27th. There have been archaeological remains found at sites where these boring holes or where similar geotechnical work was happening in the past. And it is known, right, kind of because the Delta is an ever-changing kind of fluid, living thing in some sense. The tribes who lived with the Delta and in the Delta, right, it's not like they put one spot down and everything always happened there, right? The rivers moved, the riverbeds moved, the locations moved. And so it's not as easy as knowing, right, if we just avoid this one location, everything will be fine. And I think the other thing that those declarations show is that the mitigation that is described in the final EIR and that DWR has used in the past are inadequate to ensure that there is not harm to those resources. And there is no impact that, right, if impacts happen to those resources, right, those harms are irreparable. The fact that DWR is going to put the dirt back into the hole when they're done, right, does not mitigate or erase the harm that is done by disturbing those resources if that occurs.
And if, let's say, assuming they wanted to bore at a known site, is that possible? Is there a process? If somebody wanted to take borings of a known burial ground or archaeological resource that is known, is that even possible under the law?
So I'm going to defer largely to the tribes who would be impacted by that, right? That is not a question that I can answer for them, right? If there is a known site that, right, is,
so that is
native
not
tribe knows
one of
it
their
exists.
claims. That is not one of their claims that you're here to assert.
So I am not saying that I know at the bottom of hole 242, there are going to be archaeological tribal cultural resources, right? If there is a site that is known to have a tribal cultural resource,
That's what I'm
added,
asking.
right?
I'm
Then
asking
the right
that.
thing for the Department of Water Resources to do is what the tribe says should be done. And it should go to the tribe. This is what we want to do. This is what's there. This is what we know. That is your resource. That is a sovereign nation's resource.
Mhm.
It gets to choose whether that can go forward safely or not. The department doesn't get to dictate that. I don't get to dictate that. I don't
I'm
think
just
the council
asking
does.
it to, if it's even possible, is it legal? Is it allowed?
It's up to the tribe.
Hmm.
And I don't know how the tribe is going to handle any of those.
I would assume they
specific-
would not want that.
I would be very surprised if
assume
they allowed
that they would not want that. And if they did not want that, it would not be possible.
I think it should be up to the tribe. If that was the tribe's determination, I would say that then it is not possible to do that.
Okay, thank you.
Any other members have any questions? No, I'll ask a question. So what I was going to say before Ben started was, I think it's important to keep in mind that the scope of the council's review is limited to whether or not the certification of consistency was supported by substantial evidence in the record. So we're limited in what we're looking at here. Number one, I think it's important for everyone to keep that in mind. And then secondly, I wanted to go back to your CEQA, equating CEQA to a covered action as being exactly the same. Isn't that exactly what the legislature did by creating a separate process? I guess I would pose a question to you. Isn't the certification of consistency process a separate process from CEQA under a different statutory scheme?
So let me start with the second question first, and then I'll come back to your comment at the outset. 100% yes, right? The purpose of the Delta Reform Act is different than the purpose of CEQA. They are independent statutes. The things that, right, any agency or project sponsor has to analyze under CEQA are different than the things that they have to analyze under the Delta Reform Act, right? The Delta Reform Act says, protect the Delta. Here are our two co-equal overarching goals. Go from there, right? CEQA says, analyze all of the impacts to the environment or the foreseeable consequences of a project. And so they are analyzing different things. But what they analyze, the subject matter that they analyze, that they run through those different processes is identical, right? The project and the covered action are the same, right? We analyze a project under CEQA, but you analyze the same thing under the goals and objectives of the Delta Reform Act and a consistency determination. So I agree they're separate statutes with different purposes, but in terms of filtering what has to go through that analysis to understand the various impacts, you start with the exact same thing, right? A project or a covered action is a project as defined under CEQA. And I want to come back, right, on the scope of review question. If the question before the council is whether there is substantial evidence in the record as to how the activities that DWR proposes will impact the co-equal goals under the Delta Reform Act, right? That's a substantial evidence question. I agree with you. If that's the question we're analyzing today, or at the end of the day today, we have missed the forest for the trees. Because ultimately, the council cannot issue a consistency determination for a thing that is not a covered action. And, right, we walked through the statutory side, but DWR also says, according to the checklist, this is not a covered action, and then proceeds to move forward anyway. And making that decision after having separated a covered action from a project leads to a whole bunch of illogical and arbitrary choices from DWR that this council, I think, is required to reject under the Delta Reform Act. And that legal question of, is this a covered action, is not a substantial evidence question, right? The text of the statute's crystal clear. The court reviews that de novo. That's not something that the council can change or that depends on, right, the burden of proof or the substantiality of the evidence.
Any further questions?
I
Yes,
have a
Councilmember
question.
Maranian.
Yes, I just have a question. So when we think of the CEQA process on any infrastructure project and the steps that it goes through, so do you believe, under what you just said, do you believe that every step of the totality of a project should go through CEQA in any project? Because these are large scale infrastructure projects that have steps, phases, requirements. And under CEQA, do you believe that each of these phase and step, or do you believe that CEQA does that for every other project that is of this scale and this nature?
So generally, yes, right? CEQA demands that you analyze the entirety of an action, the whole of the action, right?
Sure.
And there are some exceptions to that where you do, a programmatic one, and then a project changes a little bit later, and so you do a supplemental analysis. But those aren't applicable at all here. So generally, the answer to your question is yes. And if you look at this project, it's exactly what DWR says it did, right? It finalized and certified an environmental impact report that is 30 odd chapters and thousands of pages long, and says we've identified, right, all the aspects of the project, all the foreseeable impacts, and we've looked at the construction, operation, and maintenance of a 6,000 CFS tunnel to extract water from the delta for delivery elsewhere, right? So that's what it did in this case in CEQA. What the department did is analyze the whole of the action. That's what it's required to do here for a consistency determination, and it has not done that.
Any,
How would you define the covered action?
So the covered action in this case is the exact same thing as the project, which is the 45-mile tunnel designed to the construction, operation, and maintenance of the 45-mile tunnel designed to divert up to 6,000 cubic feet per second of water from the delta for delivery elsewhere. That's the project as defined by the Department of Water Resources. That's the covered action that the department says it will eventually submit to the council, but that's the covered action that's at issue or should be at issue here. And the department has not pretended to do a consistency determination for the entirety of the project.
thank you, Mr. Boucher, for your time.
Thank you very much for your time and questions as well.
We're going to move on to appellant number 2. This is the South Delta Water Agency. And as a reminder, please state your name when you come up to the podium.
Standing or sitting here?
Good morning, council members. My name's Dan Nomalini Jr. I'm an attorney for the South Delta Water Agency. The agency is comprised of approximately 146,000 acres within the South Delta. The agency is part of Ground Zero for the geotech activities at issue here and Ground Zero for the Delta Conveyance Project. I wanted to give a brief overview before I go into the PowerPoint slides. And I'd like to say we support the points that were just raised by the baykeepers. And what DWR is attempting to do here is egregious. There's no other way to say it. It's egregious because it is very clearly contrary to the Delta Reform Act, as well as a recent court order. I'm going to focus on why it is contrary to the Delta Reform Act. Another appellant's going to go over the court order in detail. And as most of you are aware, back on December 21st, 2023, almost exactly a year ago, DWR officially approved the Delta Conveyance Project. And I'm going to talk a lot about what that project is. It's undisputed that the Delta Conveyance Project is a covered action under the Delta Reform Act. It is further undisputed that DWR must file a certification of consistency for the Delta Conveyance Project before it can implement it. Where DWR has gone grossly astray is in its attempt to certify only a small piece of the Delta Conveyance Project rather than the entirety of it. What it's certifying here is the so-called 2024-2026 geotechnical activities. Now, if I could bring up my slide presentation. Okay. I realized it'd take me a half hour to get through this, so I'm going to keep it brief, and I apologize to the court reporter to kind of rush through it, but there's some big points I want to make, and I think it's going to be helpful. It's going to bleed off of what was just discussed, but the big issue here and the big point is DWR's attempted certification of a portion of the DCP must be denied because under the Delta Reform Act, the whole of the action that comprises the DCP must be certified together in the same certification. And DWR has not done that. It has not certified the whole of the action that comprises the DCP. And I have here DWR effectively concedes the latter. It more or less agrees it hasn't certified the whole of the action. It says that's coming a year later. But then again, it tries to wiggle out of this and say and claim these geotech activities are not part of the whole of the action. So they're being inconsistent. But the main issue is whether the legislature intended that the whole of the action of the DCP must be certified together in the same certification. And it can be easily demonstrated that it did. And go to the next slide and then skip over that one more. Now, the legal analysis, which definitively confirms DWR is supposed to certify the whole of the action, not a piece of it. The legal analysis is as straightforward and simple as it gets. A lot of times the law is vague, it's unclear. This is very logical and straightforward, and that's why I want to walk through this quickly. So I'm going to read this. I don't know how big it is for you, but the legislature defined what a covered action is. And it said it's a plan, program, or project as defined pursuant to section 21065 of the Public Resources Code. That section is part of CEQA and defines project as an activity which may cause either a direct physical change in the environment or reasonably foreseeable indirect change in the environment. Prior to the creation of the Delta Reform Act in 2009, it was well established in CEQA's regulations and case law that project under section 21065 means the whole of the action, not a piece of it, not part of it, the whole thing that may cause direct or indirect physical changes in the environment. Now, this next part is super important, and DWR should be fully aware of this, but it didn't mention it and conveniently ignores it. But this is a quote from our Supreme Court. It says, the legislature is deemed to be aware of existing laws and judicial decisions in effect at the time legislation is enacted, and to have enacted and amended statutes in the light of such decisions as have a direct bearing upon them. What that means is when the legislature stated that a covered action is a project as defined pursuant to section 21065, the legislature knew that project under that section meant whole of the action. And therefore, it intended that a covered action include the whole of the action that comprises that covered action. Again, this is as straightforward as it gets. So there should be no confusion or debate that what DWR needs to certify is the whole of the action. And so that raises the question, did it do that? Did it certify the whole of the action? And if you can go to the next slide, please. I'm going to explain to you as quickly as I can that no, it absolutely did not. It came nowhere close to doing that. And in order to figure out, one of the council members noted, what is the whole of the action? In order to figure that out, you got to go back to December, a year ago, and look at what it approved. Back on December 21st, after certifying its final EIR, DWR issued a formal notice of determination declaring and informing the public that it approved the DCP. In particular, DWR approved the following: the construction, operation, and maintenance of a new state water project water diversion and conveyance facilities in the Delta, i.e. the DCP. Now, if you read DWR's materials, they make it sound like all DWR has approved so far is further studies, like more analysis of their alignment. That is false and misleading because DWR approved the actual construction, operation, and maintenance. So if you go to the next slide, please. So I made a pie chart. This is the whole of the action. This is what we should be talking about today. Their paperwork should be much thicker than it is because it should have included construction, operation, and maintenance. It should have included everything it approved. If you go to the next slide, please. DWR didn't do that. What DWR did is it carved out the construction component. And some of my highlighting is not showing up there, but the construction component of the project is made up of pre-construction activities and during construction activities. So DWR focused solely on the pre-construction activities. And on the right, this is strange how the slides don't have my stuff on it, but on the right are all the activities that are part of the pre-construction activities. The only piece of those activities that DWR brought before you today are part of the top there, the soil boring, CPTs, and groundwater. It left out all of those other geotechnical activities. So if you go to the next slide, please. And with regard to the soil borings in CPTs, as you've heard, they didn't even include all of those. They limited them to the land-based ones. They excluded everything over the water. And then for the land-based ones, they only looked at a limited number of them. So if you go to the next slide. Wow, these slides are all messed up. How funny. That is weird. Okay, this chart was showing you the whole of the action once again is the construction, operation, and maintenance. And what should be on that screen is a little red sliver in the construction area showing the little bite-sized piece that they are certifying today. The next slide, please. Okay, I'm just going to read this on the top. The degree to which DWR chopped up the DCP into pieces for purposes of certification and implementation of the DCP is staggering. What DWR is attempting to do cannot be remotely reconciled with the legislature's intent in Water Code Section 85225 that the whole of the action that comprises the covered action be certified together prior to implementation of that covered action. It didn't even come close. It didn't even do the whole of the action of the construction phase. It didn't even do the whole of the action of the pre-construction activities. It didn't even include all of the borings. So this is amazing to us. Everybody who reviewed this had the same reaction, including the Delta Protection Commission, that this is simply misplaced. And if you don't believe me, I have this in my slides you can look at, but if you don't believe me on what is the whole of the action, you just need to read its notice of determination that it filed a year ago. And in that, it stated that the geotech activities are one of the key components and actions of the DCP. So it admits that it's part of this bigger thing. There is no denial of that. And just to quickly say, another fatal problem here, I explained this in my slide, but I'll just do it orally here, is DWR wants you to violate the whole of the action principle and separate this from the whole of the action. If you were to do that, which you shouldn't because it's clearly unlawful, but if you were to separate it, there's another fatal flaw because as I've been explaining, they don't even include the whole of the action of the geotechnical activities. They only took a piece of those activities. So the level of just destroying the whole of the action, the level of just disregarding that legislative intent is truly, it's shocking. And I'd just like to conclude here that there's absolutely, and this is not on my slides, but there's absolutely nothing preventing DWR from certifying the whole of the action of the DCP right now. If it wants to start implementing the pre-construction component of the DCP as soon as possible, then it can and should file the certification for the entire DCP as soon as possible. And you'll notice if you read its materials, it never states that this geotech information is necessary for it to file a certification of consistency for the entire DCP. The most it states is that this info may inform a future certification of consistency for the DCP. The reason is because this information is absolutely not necessary. It can file the certification for the entire DCP tomorrow. It could have done it a year ago. The worst thing that would happen if it files it tomorrow is that the council denies it and sends it back to DWR with instructions on what it needs to fix. That's how the certification process works. If your certification is denied, then you get an opportunity to fix it, and you'll know exactly what you have to do to fix it. So the certification process is not broken. The process works just fine and will work just fine. The problem is that DWR has grossly failed to comply with that process. Accordingly, we respectfully request and urge that the council remand the matter back to DWR on the grounds that DWR has failed to include the whole of the action of the DCP in its certification. We also request that the council remand the matter back to DWR for the other grounds we raised in our appeal and we did not have time to discuss at this hearing. And there was a comment about the scope of the Stewardship Council's authority is simply to look at substantial evidence, something to that effect. What we have here is a massive procedural error that you folks have to address as a procedural error, but it can also be viewed as a failure in substantial evidence, because the fact that they left out 90% of the whole of the action means they don't have substantial evidence for 90% of the whole of the action. So there's actually, by them not following the whole of the action requirement, they also have a colossal failure of substantial evidence, because they don't even try to produce evidence to support the whole of the action. So I could go on and on. I appreciate your time, but I'll leave it at that. So thank you.
Thank you, Mr. Namalini. Before we move forward to council member questions, did you have a comment, Jorge?
Yes.
Yeah.
We want to, after perhaps we're done asking questions of Mr. Namalini Jr., if we could take a quick break, we want to make sure we're checking the slides, because in the last one, it was out of order. So we just want to double check that there's no other malfunctions.
Okay, good. I was going to ask that too. If staff could double check if we're having an issue with the slides. Everything that the state has to put up has to be accessible. And so, you know, it could be just an issue with the transference and making the slides accessible.
Yeah,
So
it's
we'll
no
check
problem.
into it though.
It's no problem.
For
Thank
sure.
you.
Okay. And do council members have any questions for Mr. Namalini? No, none at this time. Okay, thank you, Mr.
Okay,
Namalini.
thank you.
Appreciate your presentation. We're going to move on to appellant number 3, which is the County of Sacramento et al. And please, again, state your names for the record. Thank you.
5 minutes?
Yeah, we're going to take a 5-minute break. I'm sorry, I apologize. I thought you meant after all the presentations. And I'll note for the record, which I failed to do, when Vice Chairperson Miller came to the meeting. So she was in attendance and she has stepped away for a moment, but she'll be back shortly. So I think to keep us on schedule and on time, though, we want to go ahead and move forward. So I'll welcome our next appellants, County of Sacramento et al. Can you turn on all the mics, please?
Okay, there it goes. Okay. Let's try this again. Good morning, Chairley and members of the council. My name is Luwinda Lacey, and with me is Kelly Tabor. We work at Somex Simmons and Dunn, and we represent Appellants County of Sacramento, Sacramento County Water Agency, Sacramento Area Sewer District, and the City of Stockton.
Welcome, ladies. I don't want to interrupt your presentation, but I do want to assure you that we've looked through the presentations. We did have a slight glitch with making some of them accessible, which happens sometimes when you transfer things like that, but we've double checked the next 2 and we'll make sure that we get the first 2 out there to the public on any slides that may have gotten a little bit tweaked when we transferred them. So thank you.
Many thanks. First, I just want to echo the statements that Mr. Busher and Mr. Namalini made, with which we agree, is that the covered action is the whole, the Delta Conveyance Project is the whole of the action. It's not a sliver of it. It is the entirety of it. The Department of Water Resources argues that CEQA is irrelevant to what a covered action is, but their own brief is replete with citations to CEQA cases, and that is for good reason. The legislature indeed incorporated the definition of project under CEQA within the meaning of what a covered action is. And I don't want to belabor that point again, because they've done a really good job of explaining that to you, but I do want to start at the beginning. Why are we here? The department states that it is here under protest, that it was told by the court to come here and seek a certification of consistency for these geotechnical activities, and that is incorrect. I want to first just take a step back and address the question of the council's review. The standard of review is substantial evidence, and that is true. However, what the council initially has to determine is whether it even has jurisdiction to consider DWR certification of consistency? And we contend the answer to that is no. May I put my slides up, please? If the council does not have jurisdiction to consider the certification of consistency, contrary to what the Department of Water Resources has said, the council must approve our appeals and must grant them. And the reason I say that is because it's consistent with practice before trial courts. If you file a motion to dismiss for lack of jurisdiction, the trial court grants that motion and then does away with the action before it. And that's the same thing that we're asking the council to do here. So can I get my first slide up? My second slide, I'm sorry. So let's go back again to what a covered action is. It's a project under CEQA, and there are other provisions, one of which is that it has to have a significant impact on one or both of the Delta Reform Act co-equal goals. DWR here has admitted that it is not a covered action because it expressly states that the geotechnical activities before you would have no impact on the achievement of these co-equal goals. And the facts show that this is not a covered action either. So going back to the beginning, next slide, please. Okay. DWR argues that it's here because the trial court required it to do so. To take a step back, after the Department of Water Resources certified its final environmental impact report for the project, which is the Delta Conveyance Project, there were a number of there was suits filed in the Sacramento County Superior Court challenging that final EIR, Environmental Impact Report. The Department of Water Resources thereafter moved forward with geotechnical activities to implement the project, to implement the Delta Conveyance Project. And there were motions for preliminary injunction filed in Sacramento Superior Court to preclude the department from doing so. What was before the court was the following question: whether the department's plan to undertake geotechnical investigations prior to certifying the DCP, the Delta Conveyance Project, as consistent with the Delta Plan, violates Water Code Section 85225 under the Delta Reform Act, which requires certification prior to initiating the implementation of a covered action. The court explained that its determination of this question was an issue of statutory interpretation, which is vested in the trial court. Next slide, please. The Department of Water Resources argued before the trial court as follows. It argued that the petitioner's interpretation, which was that the Delta Conveyance Project in its totality is the covered action, and therefore a consistency of determination had to be made as to that entire project. They said it was unworkable. And they claimed that they were afraid that even though they had completed all of the in-depth studies and analysis and specificity required under CEQA, it does not yet have enough information to self-certify the DCP is consistent with the Delta Plan. They also argued that it would not be able to prepare such a certification until it completed the geotechnical work that is at issue here. Next slide, please. The trial court disagreed with the Department of Water Resources. The trial court explained DWR's argument ignores that implementation relates to covered action, which is defined as consisting of the project under CEQA, and the CEQA project in this case includes the geotechnical investigations. The court said the department offered no case law or any other legal support for its position that it would be allowed to define the covered action more narrowly than what is stated under the statute. And just because the purpose of the geotechnical work is to gather information to aid in making a final design decision, it did not mean that it is not a component of the project that requires implementation. So the geotechnical work, just like the ultimate project construction, will likely have an impact on the environment in the Delta that not only requires CEQA review and approval, but also certification of consistency with the Delta plan. And the court said that under the Department of Water Resources interpretation, the court would have to ignore the plain language of the Delta Reform Act and create a new exemption for the DCP, which it cannot do. Next slide, please. So the court's ruling was that because the geotechnical work is part of the project, here the DCP, within the meaning of CEQA, because that is how the project was defined in the final environmental impact report, it is necessarily part of the covered action within the meaning of the Delta Reform Act. Next slide, please. The court thus concluded the geotechnical work at issue here is part of the covered action, which requires certification of consistency with the Delta plan before it is implemented. As you can see from here, the court did not direct the Department of Water Resources to file a certification of consistency for the geotechnical activities that form part of the covered action. Next slide, please. Oh, sorry, go back. But to this point, this council does not have the authority to overrule what the trial court has said. The Department of Water Resources is taking this up on appeal. It is currently pending before the 3rd District Court of Appeal. Prior to the trial court losing jurisdiction over the preliminary injunction motion, the Department of Water Resources sought reconsideration and sought to modify the preliminary injunction. As part of that motion, what DWR argued was that the geotechnical activities at issue here, the 2024 to 2026 geotechnical activities identified in the certification of consistency, they asked the court to excise that from the preliminary injunction, and the court declined to do so. The Department of Water Resources sought a petition for writ of supersedious in the Court of Appeal, seeking to stay the preliminary injunction so that it can move forward with the geotechnical activities. The Court of Appeal denied that motion. So what is happening here isn't that the Department of Water Resources is trying to comply with the trial court's ruling. They're trying to end run around the trial court's ruling. This sham certification is further concerning because it does raise some due process concerns and the appearance of bias and impropriety. The Department of Water Resources has stated that it has been an early consultation with council staff on the Delta Conveyance project. And there's no information that the staff who's been advising DWR has been walled off from the decision makers that are sitting before us today. And to that point, Mr. Henderson actually drafted a declaration in support of the Department of Water Resources motion in the trial court. And he is the staff person who has been speaking on this issue before you today. This is akin to going to a trial and learning that the research attorney was meeting with opposing counsel. Additionally, the process here has created concerns with regards to due process. In any other appellate proceeding, you can file a reply brief. And for good reason, you have a burden of proof. Here, the department dropped a 60-page, single-spaced written submission, approximately at 5 o'clock on a Friday. Appellants were required to provide slides the very next business day. When we asked for an extension by 1 business day to provide slides, that request was denied. And we contend that just does not comport with due process. I did want to briefly mention the Delta Protection Commission. The Department of Water Resources asserts that the council should strike the commission's recent submittal. We disagree. The council, a member of the council did provide an initial letter to the council of the commission, provided an initial letter to this council outlining concerns with regards to the certification of consistency. Therein, that person wrote that there had not yet been a meeting by the commission in order to consider what was stated in that letter, but that a meeting would be forthcoming. The meeting of the commission is known to, is subject to public notice and is known to when such meetings would occur. It would be prejudicial, especially given the standard that should apply to the commission's testimony as an expert, to preclude the commission's written submission in that regard. The other things I just wanted to mention, since we're running short on time, is that the Department of Water Resources is also seeking to strike our harvest technical memorandum that we submitted in support of our appeal. We believe it is admissible and subject to the regulations because it contains generally accepted technical and scientific matters as stated in our written submission. Additionally, I do want to address that the DWR's position that our appeal should be, our argument should be waived with regards to the harvest technical memorandum because we didn't specifically outline the impacts to land use conflicts. I direct the council to page 19 of our appeal where we did. Further, the Department of Water Resources has stated that it has coordinated with Sacramento Area Sewer District regarding the harvest water program. However, it did not address all conflicts that are relevant to this appeal during those conversations. The harvest water tech memo does explain the impacts of vehicle activity hours and how they are connected to specific species and relevant to the Delta Plan as well. And Ms. Tabor wanted to just address a prior question.
Thank you, Kelly Tabor, also on behalf of the County of Sacramento et al. I just would like to follow up on Councilmember Hueso's question about whether the proposed activities that are before you today have any informational value. And that whether the activities have value for the DCP as a whole or in the abstract for the Delta is not relevant to your consideration of this issue. This issue was before the trial court. The department argued that this was information that was helpful. They should be able to proceed. It wasn't harmful. The court heard all those arguments and rejected them. The court focused, as you've heard now in 3 presentations, on this fundamental jurisdictional issue that the department itself had defined the entire DCP as the covered action, and that it wasn't possible to create an exception for any sliver of that activity, no matter how useful that information would be. In effect, this was a problem of the department's making. If it wasn't ready to submit a certification for the whole project, it should have waited to certify the final environmental impact report. It was proceeding to do work under separate CEQA review over the years. It could have deferred until it had enough information to make an informed decision. It didn't follow the rules. The court rejected that, and you should do the same.
And we'll just, in conclusion, just state to protect the council's integrity and purpose, we respectfully request that the council grant the appeals and reject DWR certification of consistency for these geotechnical activities. Thank you very much.
Thank you for your presentation. Members, does anyone have any questions? Yes, Councilmember Burgess.
Just clarifying, and I'm trying to make sure I stay within the questions that I should be asking, but so are you saying that, so we're looking at this idea of whether it is consistent or if it is actually something that should be heard. And it sounds like what you're saying is that this little piece that it's been called a couple times is actually being used for the whole. Is that kind of what I'm trying to understand?
Well, the department defined it as part of the whole, and
Right.
that was the key legal issue here.
Okay. And so do you think that that then allows other things? I'm trying not to step outside. I'm just trying to figure out if I understand there's a whole, what we're trying to figure out, and I'm trying to use the terminology consistent with what we're doing. So are you saying that? I want to ask the questions that are appropriate. So that's why I'm
Is the
having a little bit-
concern, council member, that you're articulating that if the council were to deny the appeals and uphold the certification, that this would set a precedent that would allow the department for this project or other
right, does this
project
happen-
proponents to proceed with serial certifications and never get to some point far down the road without ever having considered the whole project?
Yeah, that's kind of.
And
where
that
I'm
is,
going.
I think, the point that Mr. Busher and Mr. Nomalini made, and that we would agree with, is that this has to accept the department's interpretation here and reject the trial court's interpretation would have very significant consequences for the larger DCP, but you don't have to think about it in terms of the DCP. You should be thinking about your jurisdiction and the role of the council going forward, because any project could take the same approach. If let's say I have a huge wastewater treatment plant project in the Delta, and that's clearly a covered action, and I've admitted as much in my EIR for that. But I try to, rather than come to you before you with a full certification, I just piecemeal it, and I come in with little bits at a time, so the council never gets to see the effect of the project as a whole, and that project can get so far down the line and partially implemented before, and perhaps to the point where the final certification is a foregone conclusion. It becomes just a post hoc rationalization for the larger project. Those are I think the council should be considering the precedential effect of agreeing with the department's position here, in addition to the specific legal issue that's before you for the geotechnical activities.
And the idea that using the definition under CEQA for project, is that kind of, well, I'll ask DWR because that's really for them to answer, but in your opinion, is there another way that it could have been stated rather than using that particular definition? Because I think that seems to be what's the problem with a lot of folks, is that
whether the department could have defined it differently.
Yeah.
Well, they could have, but they chose to approve a project that included all of these activities, and the court's ruling focused specifically on the fact that these were defined as part of the
I'm
larger
just curious
project.
why that particular was used. So, okay, thank you. I apologize for not having clear questions because I'm thinking as I'm listening. So.
Well, there's no apology needed because these are not. It's a complicated set of questions before you. We've been through this through 2 rounds of briefing in the trial court already, and I understand we're here to try to help make our position clear. Mm-hmm.
Anyone else have a question? All right. You mentioned that covered action is the whole of the action, and we've established that the covered action process and the CEQA process are 2 different statutory schemes. So where in the Delta Reform Act does it refer to the whole of the action, I guess would be my question.
It does not, Madam Chair. How the whole of the action comes into this, and Mr. Nomalini cited the California Supreme Court decision explaining that once the legislature refers to another statute in a statute, it imports court cases that have interpreted that statute. That's how we interpret it. And the fact that the legislature included within the definition of covered action, specifically referencing project under CEQA, we must presume, based on California Supreme Court decision, that the legislature knew what the definition of a project was under CEQA. And we have 5 decades of case law establishing that a project is the whole of the action. And the reason for that is to avoid piecemealing. And what that means is because when you piecemeal a project, for example, when you sliver it and you take it out, you cannot see the whole picture to determine what the cumulative impacts are from that project. And so that's how the whole of the action language, essentially, if you want to call it that, came to be.
And the legislature, as I think Mr. Busher and perhaps Mr. Nomalini said, could have chosen a generic definition that didn't specifically incorporate the CEQA project definition and everything that comes with it. It could have created an exception, notwithstanding that definition, for preliminary activities or planning activities, but it didn't do so. And so it's not within the council's discretion to read an exception or an exemption into the statute when the legislature didn't do so itself.
And when a trial court has specifically said under statutory interpretation that it agrees that it is the whole of the action.
And equating CEQA to our process in terms of the definition of project, is it your contention that every CEQA project is a covered action then?
No, remember we'll refer you back to your covered action definition, which includes a project as defined under CEQA that will have a significant impact on the achievement of one or more of the co-equal goals and implicates the Delta Plan policies.
Exactly. And to that point, Chair Lee, it is not that every CEQA action would fall under the Delta Reform Act, but every CEQA project that also meets those other requirements under the Delta Reform Act is subject to the Delta Reform Act. So it's a portion of what a covered action is.
And again, the department made its own decision that the DCP was a covered action and that the DCP was defined by the department to include the activities that are here before you today.
All right. Any other questions from members? No. All right, ladies, thank you very much. Appreciate your presentations. Right, at this time, we'll move on to our fourth appellant. This is San Joaquin County et al. We have some nameplates if you want to choose them over there. And then please also verbally state your names for the records before you begin speaking so the court reporter can capture that. Thank you.
Sort of an IQ test. I get to find my name.
Okay. No, you're free to just let us know verbally. Thank you. Sorry about that.
I hope this isn't an indication of our status.
Don't take it personally.
Okay. Good morning, Chair Lee and members of the council staff. My name is Osha Meserve. And together with Mr. Keeling, we're here on behalf of San Joaquin County Central Delta Water Agency, as well as local agencies of the North Delta. Mr. Keeling will be addressing some of the procedural issues, adding on to what you've heard already this morning, and then I will be discussing some of the inconsistencies with specific policies, as well as, thank you, some of the other issues in our appeal. So with that, I'll turn it over to Mr. Keeling, and I believe he wanted to see slide 2, if that would be all right.
Slide number 2. Yes. This is essentially what you've been hearing before, so I'm not going to repeat what others have said about DWR attempting to use a sliver or piece, but I'll take credit for our using another analogy, a small chip of a large boulder. The boulder being the real covered action, the DCP, and the chip being not the geotechnical investigations, but a small subset of the geotechnical investigations. And it was DWR, as I believe the folks for Sacramento said, it was DWR that chose to make the proposed geotechnical activities an integral part of the DCP, the covered action, and not a separate standalone project. Because the points about piecemealing have already been covered, I won't repeat them, but suffice it to say that this is a classic case of piecemealing. This is not the whole of the action, as Mr. Nomalini said, and DWR doesn't bother to dispute that. But I would like to direct your attention to something. You have not yet seen DWR's slide number 7. You're going to see it, I hope. When you do, we ask that you bear this in mind. Slide number 7, DWR slide number 7, says that the question before the Superior Court was, quote, whether DWR was required to file a certification before conducting the geotechnical activities. That statement is false and misleading. The question before the Superior Court was whether DWR was required to submit a consistency certification for the DCP itself, which was the covered action at issue. There was never any suggestion in that proceeding that the issue before the court was whether DWR could slice off a piece of the covered action that is not itself a covered action. The point of the slide that DWR has not shown that the geotechnical activities have separate utility has been addressed by other parties. And by that we mean there's no standalone project for the geotechnical activities. There's been no showing that they have any utility other than as a part of the Delta Conveyance project. Slide number 4, please. That's 3. I need 4. There you go. Thank you. This is a high-profile proceeding, one that focuses the public eye on DSC, the DSC's pivotal role with respect to the Delta. If the council allows a party to get away with a sort of sleight of hand piecemealing that is being attempted by DWR in this hearing, the message to Delta counties and communities, as well as to the state as a whole, will be very clear. In order to skate by on a consistency requirement, all a party needs to do is piecemeal the actual covered action, thereby obscuring the effects of the covered action, of which that piece is but a fragment. I believe Ms. Tabor gave the example of a wastewater treatment plant, and that is exactly what I'm talking about. DWR's brief, by the way, is replete with cites to CEQA cases. We didn't write their brief, they did. And those cases undermine DWR's argument that somehow CEQA is not relevant to the determination of what constitutes a covered action. I could go into more detail on that, but I would be repeating what you've already heard by 3 other appellants. A word here, I think, about the standard by which this council is to discharge its duties in this proceeding. Regarding Mr. Henderson's overview at the beginning of this hearing and DWR's slide number 8, which you have not yet seen, there's something you should keep in mind, especially as you get to slide number 8. Slide number 8 says, and it's all about substantial evidence, it says that although it says that the standard of that the substantial evidence standard of review applies here. Although DWR's explanation of what that standard is not inaccurate per se, DWR neglected to mention the obvious. That standard applies only to evidentiary matters, to questions of fact. It does not apply to questions of law. It does not apply to questions of due process or conformance with legal procedure. The primary argument, put it this way, the substantial evidence standard has absolutely nothing to do with the first and primary issue before this council, which is whether DWR's consistency certification is properly before this council in the first place. That's entirely a matter of statutory interpretation, and for that matter, a plain common sense reading of the court's order, which, by the way, is the only reason DWR submitted anything at all to this council. Those are questions of law, not factual issues. I'm going to give the rest of the time to my colleague, Ms. Meserve. Thank you.
Thank you, Mr. Keeling. I will touch on a few more items in our slides. Of course, we refer to our more extensive briefs that were submitted. If we could please show slide 3. This is from DWR's consistency determination, and this is just a few of the maps that are labeled as map books, page 1 through 10. And you can see the first one is, I did not count these red dots, but this is at the proposed tunnel launch area at Twin Cities Road in Sacramento County. And you can see that what is currently a pasture land and farmland and also serves all other kinds of agricultural uses is riddled with holes. So I show this as well as a couple of the other slides where launch shafts and other facilities are proposed to show that even looking at only this chip off a chip, there is a lot of disturbance on the land that is proposed. And that is why we've also checked the boxes in our appeal for being inconsistent with the co-equal goals, as well as the Delta protection of DPP2 respect local land uses. If we could go to slide 5, please. Actually, I will mention, we also briefed and commend the council to look at the mitigation measure support or the lack of support in the consistency determination submitted by DWR. It didn't do a crosswalk table, which normally certifications include. And so it's asking the council to do its DWR's job, which is to find the correlations between the Delta Plan mitigation measures and what's proposed here. And a lot of the times when it says it's doing mitigation, it also says in the same breath that DWR isn't going to do mitigation at all because it's not required. And then with respect to the co-equal goals, we submitted evidence in support of, and the code says that in 29702A, that the co-equal goals includes protection of the Delta as a place, and nowhere in the consistency certification does DWR ever reference the full definition and work through the what that would mean to be consistent with the co-equal goals. And also included is the ecosystem, and DWR in its certifications states that it will have no effect at all on things like natural landscape blocks and essential connectivity areas. But that is belied by the fact that all these holes and the other activities go right across those same areas. And there's additional evidence in the Sacramento County appeal regarding that should be considered, as well as DWR's own maps in its EIR and other materials that we've cited. With respect, if we could go now to slide 5 or slide 6. With respect to the disruption of the communities and the lack of respect for local land uses, one of the other issues that we've talked about and we think ought to be a basis for grant of the appeal is that there won't be any oversight of, let's see if we want to go to one more slide. That's fine. There's not any oversight of DWR with respect to the borings. There are very technical requirements for making sure that they're sealed, because these borings go into the groundwater, and they also, while this subset of activities is not in levees, it is in places that are near levees, and it's very important that these holes be properly sealed. According to the court order that we put in as SJC 5, I believe, or actually SJC 4, DWR fought against having the counties be able to, the county health departments be able to oversee the sealing of the borings, and they've prevailed in that case. So while they've said they'll comply with the bulletin, which they didn't bother to submit, we submitted it. There is no way to make sure that that has happened when all these holes are put throughout the delta into the groundwater and near levees. So that is also a way in which there's not evidence supporting DWR's determinations with respect to DPP2. I will also mention on the next slide, please. We are concerned about ethical considerations and procedural irregularities in this. As you can see from the snippet that I did receive through Public Records Act request from the council is, during the lead up to this filing of this consistency certification, continued to meet with DWR regarding the overall Delta, the whole project, Delta conveyance project, while it was also meeting with the same DWR on this chip. And then in addition, after the appeals were filed, then teams were created that supposedly separated out the functions, but we believe that created a situation where there's a potential for unfair hearing for us, the appellants and the public, because that consultation was continuing with DWR while the appeal was pending on this part of the overall action. I'll mention the evidence we've submitted, which is on the slide 8. SJC 1 was simply an article. DWR was probably present when this was happening. Really, we were just trying to get across the fact that there is a third leg of the co-equal goals, which includes protection of the Delta as a place. I'll defer to our briefing on the other matters. We would request that the appeals be granted for one or more of the following reasons. Number 1, the geotechnical activities are not the whole covered action as defined by the Delta Reform Act. They are only a slice. Number 2, DSC does not have authority to consider the certification because DWR claims in its own certification that the activities aren't a covered action. Number 3, the geotechnical activities are inconsistent with the co-equal goals, which includes protecting the Delta as a place. And number 4, the geotechnical activities are inconsistent with the policies that we've appealed, which among all the appellants includes all of the policies. If I may briefly conclude, Chair.
Yes, please.
Thank you. The future of the council is at stake in how it decides these appeals. Whether it allows DWR to divide a covered action into multiple parts is a critical issue that will follow the council after today and when its decision is issued. Please carry out Delta policy and the mission, duties, and responsibilities that the legislature gave you. Thank you.
Thank you. All right, Dan, do we have any questions from our members? Yes, Councilmember Burgess.
So related to, you talked about crosswalk, and that's a term I'm not familiar with, so I apologize. And you discussed the mitigation. Can you give me a fairly short answer on a very complicated thing, I'm sure?
Thank you. I don't think it needs to be complicated. And in my experience, having done a couple of these appeals with the council, typically the certification includes a table that, because Appendix O of the Delta plan included your mitigation measures, and GPP1 says that a certifying action must have mitigation that is as good as or better than what the council adopted when it adopted the Delta plan. And so what I noticed, and I think is a failure to support its certification properly, is that DWR didn't do any such table. And then a lot of the time, the certification says that a mitigation measure, is going to be done. But then if you look farther down, it's like a mystery hole that you go down. And then when you get to the end of it, it actually says, oh, mitigation's not necessary, because DWR, again, kind of illuminating the whole of the action that we've been trying to describe to you all, is that the mitigation measures come from the EIR, which was for the whole Delta conveyance project. And so this slice in DWR's own certification doesn't implicate a lot of the mitigation it adopted, and it's not committing to do that mitigation, and it never developed mitigation that goes with this certification that's very specific to this covered action.
Okay. And Mr. Keeling, it's my understanding from what you were saying that the court didn't suggest that this needed to come before us as a covered action, but that the whole project, it was a part of the whole project. And so that this is just an attempt to be able to keep going.
That's correct. The word "this" in your sentence, I assume, refers to this chip off a chip, the small subset of geotechnical activities. No, the court never said to DWR and never ruled that DWR is to take a chip off the covered project and bring it here. Any suggestion to the contrary is just false.
And I'll just say, as far as the early consultation, it's hard to, be able to put a light on everything, but from my understanding and talking to staff, I know there's been a really mindful, active effort to really preserve the way we conduct ourselves, our staff. So I just wanted to say that I believe that there is an effort on that part. Thank you.
All right, are there any other questions from members? No? All right, thank you very much for your presentations, Mr. Keeling and Ms. Meserve.
Thank you very much.
We will move on to the presentation from the Delta Protection Commission, and I will welcome up Mr. Blodgett for that. In here.
Good thing about glasses, don't need them to read, but then I can't see all of you. But other than that, my name is Bruce Blodgett. I'm with the Delta Protection Commission. And a couple things I want to clarify today. First and foremost, we had a meeting last week of the Delta Protection Commission on a week ago today, that evening, out at the Delta Stewardship Council's offices and remotely. At that meeting, there are two actions relevant here today. The first action was relative to the letter you received this week, early this week. That letter made it very clear there was only one change. And that change is the comments that we'd submitted earlier, the two letters that we submitted earlier, were approved by staff, completed by staff, with the commission not having the opportunity to review those or review those. Last week, the commission had that opportunity and they approved those letters. So that was the clarifying point. That was the purpose of the letter this week. The rest of the material was all the same, but I know there were some questions the other day brought up by other interests, DWR specifically, that said you shouldn't consider this letter. For some reason, they apparently don't want you to know that the commission had the opportunity to review it and approve those letters. The votes on both that letter being resubmitted and me being directed to present to you today were all approved on a vote of 7 in favor, 0 in opposition, and 1 person abstaining. Our chair Your council member Burgess and Gloria Sandoval from here at the Natural Resources Agency both recused themselves before these items were brought forward to the commission, and they actually left the building. So just wanted to clarify all of that. So again, our letter that we recently submitted is basically the same letter, other than that clarification and that vote being outlined. And again, should be considered. We listen to the arguments and we agree with the presentations from the appellants. The geotech work should not be taken out, or a chip of the geotech work should not be taken out and brought before you as the commission. It should be the project as a whole that needs to be considered. It is the project, the Delta Conveyance Project. This geotech work has absolutely no value to the Delta, none. It only has value to DWR and how they cite that project. That would be our contention. Some of the geotech work is considered an isolated project. It would still be a covered action because it has a significant effect on the achievement of the co-equal goals. The vast combined program of geotechnical operations that will occur in wildlife movement corridors and sensitive agricultural areas. You saw the one picture with the drilling rig next to the vineyard near Thornton. The disruption to get to those areas, the destruction and traffic that's going to cause, the people that are going to be trying to do those operations in an active agricultural operation or in an active wildlife corridor are going to create issues and problems. The DWR argues that the separation of the geotech work into its own consistency certification furthers the goals of the Delta Reform Act. Nothing could be further from the truth. Plain and simple, nothing could be further from the truth. This argument obscures the fact that geotech is only part of the covered action by failing to present substantial evidence for the whole of the covered action, the Delta Conveyance Project, and then thus it thwarts the goals of the Delta Reform Act. We've heard a lot about CEQA meaning of the project. We would agree with the appellants that have been before you. This is only a small chip of the major project and should be considered as a whole. I can't read my time. I don't think I'm going to even get close to 15 minutes. Certification of the geotechnical work in its own covered action is not consistent with the existing injunction. It reads, because the geotechnical work is part of the project, the Delta Conveyance Project, within the meaning of CEQA, it is necessary part of a covered action within the meaning of the Water Code. Again, the project before you today should be the entirety of the project, with the geotech work being included in that. The arguments that the geotech work does not practically presume the conveyance project or have independent utility are not based in fact or law. There is no utility. There is no value in the Delta. A $45 million investment in a project for geotechnical activities that only has one purpose, and that is Delta Conveyance, is irresponsible. Plain and simple, it's irresponsible. We also believe the geotechnical work is not consistent with Delta Plan Policy DP2. Because of the geotech work will create a vast concentration of disruptive traffic, equipment, noise, workers in an active agricultural area and habitat area. This is not consistent with Delta Plan Policy DP2. There's no real consideration of how the cumulative concentration of this work will be reconciled with active agriculture. The geotechnical work will construct facilities that are ultimately associated with the Water Conveyance Project. The fact that they are temporary, is not relevant. Nothing in Delta Plan 2, Policy 2 exempts temporary facilities. In closing, we want to reiterate that because DWR has not presented the entirety of the covered action, the Delta Conveyance Project, the geotechnical work, construction, and operations, it has thus failed to provide substantial evidence for the consistency of the covered action. We urge the council, like others have, to remand this consistency certification back to DWR to revise and present the matter that analyzes the full scope of the project and its impacts. Thank you. I'm happy to take any questions.
Thank you, Mr. Blodgett. Members, do we have any questions for the Delta Protection Commission?
I can see you now. So.
All right.
Just trying to go through the agenda to pull up, and it says attachment G, but I was having a hard time finding attachment G. Can you tell me the page number on our agenda for the letter? Is there a way of? All right, well, thank you.
We'll ask staff to look that up, Diane. Okay. All right. Thank you very much.
All right. Thank you.
All right. Members, I'm going to ask for some input from you now. Since we took a break earlier and we are a little bit behind schedule for the time that we wanted to take our lunch break, is everyone okay if we skip the 10-minute break we were going to have and just pursue on? Okay. All right, thank you. So now I will welcome up the Department of Water Resources to begin their presentation. And they have 60 minutes for that. As a reminder, if you could state your names verbally when you each get started speaking, that would be terrific. All right, let's get started.
Thank you, Chair Lee and members of the council. Good morning. I'm Carrie Buckman. I am the Environmental Program Manager for Delta Conveyance. I lead the planning and permitting activities. I wanted to introduce the other people who are here this morning, but I think just as a little bit of context setting, I've been coming here regularly for the last few years to provide updates on the Delta Conveyance project and where we are in the process. Today, we're here for something a little different. We're not looking at the entire Delta Conveyance project as we've been talking about so far this morning, but rather the plans for the next 2 years for field investigations to help inform the Delta Conveyance project. So we have a number of speakers this morning to talk about the certification of consistency that we've provided, as well as addressing some of the issues and appeals. So first, we will hear from Director Carla Namath. She is the Director of the Department of Water Resources and also has a dual role where she is the Governor's Special Advisor on Water. After Director Namath provides an introduction, she'll talk a bit about the importance of the project overall, as well as the importance of field investigations to help inform that project. She will be followed by Andrew Finney. He is the Geotechnical and Fieldwork Lead for the Delta Conveyance Design and Construction Authority. So he'll talk about what the geotechnical activities are and how they're conducted. After that, we will hear from Chris Butcher. He is our lead attorney for Delta Conveyance at DWR, and he'll talk about the procedural issues that are raised in appeals. And then we'll hear from Catherine Marquez. She is a program manager in the Delta Conveyance office. She leads a lot of our work on Delta Plan consistency, and she will talk about issues in the appeals related to Delta Plan policies. So with that, assuming we have Director Namath online, we will hear from her now. Okay, excellent. She told me she was working her way in. Let me just check.
She is online and being promoted as we speak.
Thank you. All right, so I'm going to hand this over to Director Nemeth. Director Nemeth, we did provide a brief introduction to our speakers, so it's over to you for an introduction to the project and the importance of it.
Good morning, everyone, and thank you for having me. Can you all hear me all right?
Yes.
Okay, great. So again, thank you for having us to discuss where we are with the geotech for the Delta Conveyance Project. As I know you are all aware, this project is of critical importance to the state of California. And of course, the state of California has been working on this project for quite some time. And I can say that given the changes that the state is experiencing with, what some folks call weather whiplash, but really this ability or our hydrology changing from something that's more moderate to extreme dry periods that are punctuated with increasingly large, flashy storms really does drive home the fact that developing a delta conveyance and developing a diversion point that can enable us to move that water more safely when it's available is becoming just increasingly important to the overall water management approach in California and our ability to create more climate resilient water supplies. And that essentially means moving us out of when we have drought conditions. It doesn't necessarily mean that we need to go into emergency response every time there's a drought in California. And what that does require is it requires water agencies, particularly those that depend on water that is, currently pumped out of the South Delta, to make sure that they are investing in local resilience projects as well. Things like desalination, things like stormwater capture. Of course, improved water use efficiency is just hugely important for long-term reliable water supplies in California. But even for supplies that are imported from elsewhere, like the supplies that the State Water Project moves. Those supplies are, as I mentioned, used more efficiently, but they're also recycled. So all of that work proceeds of the governor's strategy for responding to hotter and drier conditions, that trend over time across the state. But for the Delta Stewardship Council and the Delta Plan, of course, you all have very specific responsibilities around managing to co-equal goals and making sure that the state of California and other parties that are active in the Delta are doing projects that also respect Delta as place. So we have gone through an enormous amount of work in the past 6+ years, shifting from the 2-tunnel project that was proposed by Governor Brown called Water Fix to the single tunnel project that is proposed by the Newsom administration. That's the 2 diversion points and the single 6,000 CFS tunnel that is now a 45-mile tunnel as a way to also avoid construction impacts through the heart of the Delta. And as we all know, the Delta Plan itself contemplates improved conveyance of State Water Project supplies as a key feature of our ability collectively as a state to meet the co-equal goals of the Delta, through the year 2100. So I'm going to turn it over to my folks who can get into more of the technical details. But I did want to just let you all know that the proposed 2024 through 2026 geotechnical activities are essentially designed to collect valuable data that can refine the Delta Conveyance Project alignment and the Delta Conveyance Project design. It does consist of soil borings, cone penetration tests, and water quality tests. So as it's important to inform the actual development of the Delta Conveyance Project, it's also, of course, important to inform other agency decision makers, such as you all, so that you have sufficient planning and design details to make fully informed future decisions around how we permit this project. For our state water contractors, of course, they have to make important funding decisions. So this kind of information is also important to them over the course of the next 2 years, in which the department is committed to working with our state water project contractors to make sure we can fully articulate the benefits and risks of this project as we move forward. And that is designed to essentially culminate into a fuller picture of the risks, the costs, and the financial plan in this project will receive the benefit. And we're not asking folks to invest in, quote unquote, more of the project than they really need, because we very much want to stay focused on how we balance imported supplies, which as a general matter tend to be more affordable across the state because of the economies of scale. But how we balance those with our need to invest in local supplies, and all those things need to come together. So therefore, the department's ability to round out this package in the next couple of years with the technical information that supports our disclosure of the cost of the project, risk management of the project, combined with the financial plan to fund the project. Those are kind of the three pillars, if you will, that we need to bring to the table by the end of 2026 to really fully inform the state water contractors who will be determining their investment in the actual physical infrastructure. So the certification of the 2024-2026 proposed geotechnical activities is supported by substantial evidence in the record and demonstrates, we believe, a consistency with the Delta Plan. So we do respectfully request that the Stewardship Council issue a decision, and while we've listened to the appellant's argument, I think it's going to come as no surprise to you all that we respectfully request that the council deny those appeals. So with that, I think my role is to turn it over to the DWR staff that have more technical information to present to you all today, unless you all have specific questions for me. So again, thank you very much, and I appreciate the opportunity to be here.
Thank you, Director Nemeth. And now we will turn it over to Andrew Finney to talk about the project. And can we also pull up our slides at this point? Thank you.
Yes, hi, good morning. I believe it's still morning. My name is Andrew Finney. I'm a licensed geotechnical engineer in the state of California. I have over 30 years of underground design and construction experience related to large conveyance projects. I'm also serving as the geotechnical and fieldwork lead for the Delta Conveyance Design and Construction Authority. Also want to mention that I've also overseen the planning and implementation of approximately 200 explorations across the Delta in support of the evaluation of multiple alignments throughout the Delta for consideration in the environmental impact report. So I'm quite familiar with working in and around the Delta. We are here to discuss, obviously, field exploration. I think we should back up and discuss just what it is, and specifically soil borings and cone penetrometer tests, and what those constitute and why we do those, right? Why do we need the data that we obtain from those explorations? Whether it's a gas pipeline, a water treatment plant, a wastewater treatment plant, a raw water pipeline, a recycled water pipeline, all of those projects need subsurface data in order to support permitting, design, construction, and operation. And it's best practice to follow design codes and standards when you advance these projects. And in fact, that is absolutely in line with what the Delta Plan itself requires, the collection of these data. Can we skip to the next slide, please? Thank you. So the final EIR, it's correct that the final EIR identified the number and depths of all of the proposed explorations intended to support both pre-construction and construction of a Delta conveyance project. The explorations that we're discussing today represent approximately 25% of the total number of pre-construction field explorations, borings, and CPTs identified in the EIR. Just to be clear, that subset was not picked randomly. It's not meant to scare people. I know the appellants showed a slide that had what looked like a bunch of measles all over it. Many of the explorations, if not most of the explorations on that particular figure, were actually 15 feet deep, conducted in existing roads like Stockton Boulevard, Twin Cities Road, to plan and implement a pavement thickening and strengthening for construction traffic. So the actual, it's not as, we're talking about roughly 276 locations over 45 miles. Yes, there's a little bit of a cluster there at Twin Cities Road because that is an area where we proposed outside of the, in the competent soils where he had planned to do a lot of the work to close to I-5 to minimize the impacts to the public. So I mentioned there was 25%. The data from this subset of the explorations will support planning, inform the planning and design, and allow us to maintain the overall program schedule for this larger important project, support permit applications and requests, refine project feature layouts and configurations. And I would say most importantly, and Director Namath mentioned this, is support future funding decisions. The water contractors are being asked to spend a lot of money with a 10% level of design at this point. The subset of data does not include work on levees. It does not include overwater activities. It does not include activities that involve trenching, test pits. It doesn't involve any permanent facility whatsoever. Monuments, survey targets, anything like that. It doesn't, nothing is left on the site. Okay, and I think that's important to mention. Next slide, please. So just by way of background, we have on the left, we have, depending on how you're looking at, I guess left, we have a soil boring mounted on a truck. We have a soil boring rig mounted on tracks. And those are typically what we might use and would use to conduct explorations in the Delta. The work area that we're talking about is 10 feet by 100 feet. That is not necessarily the disturbed area. That's just an area that we set aside to park vehicles, support vehicles, and that kind of thing. The actual disturbed area we're talking about with the soil boring is 5 to 8 inches in diameter. All right, that's a typical diameter of a soil boring. We extend them from 15 feet, as I mentioned, at Twin Cities Road to on the order of 200 to 250 feet for some of the deeper locations. The duration is generally up to about 11 days to conduct the exploration. On average, some of the deeper borings have been taking only 9 days. Soil borings are conducted using natural bentonite clay and water mixture. That mixture is used to support the borehole and keep it open while we're drilling it, this 8-inch borehole, and also to bring the soil cuttings to the surface. All of the cuttings and all of the drill fluids are completely contained while on site. They are then drummed and hauled off for disposal at an appropriate landfill. Next slide, please. Similarly, the cone penetrometer tests are conducted either using a track-mounted cone penetrometer rig or a truck-mounted rig. Same work area, primarily for staging of personnel and inspection folks and that kind of thing. Depths
200 to 250 feet, smaller diameter. They don't use drilling mud to keep the hole open. They actually only involve pushing a steel rod into the ground, and the rod ranges in size from 2 to 3 inches. Their duration is a little shorter, maximum of 4 days. On average, it's been taking 2 days to do the 200, 250 feet. Next slide, please. So when we've completed these boreholes and these CPTs, they are sealed. All of them are sealed in accordance with the requirements of DWR Bulletin 7481 and 7490, which are the soil boring and water well permit guidelines and standards. By inserting, essentially by what's called tremming, where you install the cement bentonite grout from the bottom up to ensure that you have completely filled the borehole or the CPT. Where that exploration is conducted in agricultural areas, the top 5 feet is usually not grouted. It's usually then backfilled with topsoil, so it can be consistent with the agricultural use. One thing with regard to when you hear the word cement, it sounds very hard and like an inclusion in the ground. The cement bentonite ground that we use is similar in texture to the actual native subsurface soils. It's not concrete like you might see on a pavement or a sidewalk. Concrete is cement and aggregate. We're not using aggregate like sand and gravel. We're just using cement, water, and bentonite clay to provide flexibility to that sealing material. It doesn't interfere with farm machinery. It doesn't interfere with the ability of the farmers to install irrigation systems or to plow or deep rip their fields. What it does do is provide borehole stability and prevents groundwater contamination. And in the case where the groundwater might be artesian, which is occasionally present in the Delta, where the water is higher, the water level is higher than the ground surface, it seals those boreholes to prevent seepage. The DCDCA, or the agency that I'm working with, we document all of the backfill of those borings and the means by which they were installed in a number of places. They are detailed at the end of each boring log, the number, the amount of bags of cement and bentonite. They are also captured every day in the daily field inspection, and we have on the slide here a snip of a typical verbiage that would be included in the daily report there. Next slide. So this slide presents a sort of before and after for a couple of typical soil borings on the top and cone penetrometer locations on the bottom within the Delta itself. So before we ever set foot on a site, the sites are screened. I think it's important that we mention the sites are screened for both environmental and cultural resources. So using best available science, databases that only experts have access to and work through the tribes, we make sure that in planning the locations that they are not going to conflict with any environmental or cultural resources. Then once we mobilize, well, first we have to obtain an entry permit. Those are obtained either voluntarily with the landowner or through a court-ordered process. We contact the landowner, typically by 3 means. We send them a letter saying that we would like to meet on site and conduct the activities given a certain period of time. By letter, sorry, I mentioned by letter, by phone, and by email, contact is made. The first time that the DCDCA and DWR set foot on a site is during the site clearance survey. And the site clearance survey is conducted 2 weeks prior to the exploration. And it involves a biologist, an archaeologist, and a tribal representative, along with representatives of the field exploration staff. The specific work area, the timing, the sort of micro siting it, if you will, are all adjusted in the field based on feedback from the landowner or tenant farmer, in the event that there is a tenant farmer, with a consideration given to safety, the actual conditions in the field. Is there are there trees? Is there something unsafe that might prevent the work? And in consideration of the environmental mitigation measures, are we too close to nesting habitat or that kind of thing? It should be noted that if special status wildlife or a cultural resource cannot be avoided during that, it's observed during that site visit, they cannot be avoided, then that work is either rescheduled, relocated, or canceled. It would not advance, obviously, if it did not, it would not meet our commitments to those requirements. Once the work is completed at the site, the field coordinator would then follow up with the affected landowner, generally in person or by phone, and to ensure that the sites and the boreholes are backfilled and the roads maintained and fixed if there was anything there into the condition that leave no trace is the saying, right? We have to put it back the way it was. Now, if additional borehole fill or road repairs are required, then we work with the landowner to schedule a time for those repairs. Or alternatively, if the landowner is interested in repairing it themselves, there is a process to be financially compensated for the work that they would self-perform. And at the end of the day, we make sure that the landowner is happy with whichever process they choose to implement. And I just want to mention one other thing in passing. To date, there have been, I mentioned the borehole sealing. To date, there have been no instances where DWR has been informed or has observed inadequate sealing, water seeping from boreholes or anything like that afterwards. And we take the what we call the abandonment of the boreholes, the backfilling, very seriously, using what we consider to be best available practices. So with that, I'll turn it over to Chris.
Thank you. Good afternoon, Chair, Council members. I'm Chris Butcher, an attorney with the Department of Water Resources, Office of General Counsel. Mr. Finney just described the limited scope of the geotechnical activities at issue in the appeals today. I'm going to address 4 procedural arguments that have been raised by the appellants relating to the preliminary injunction, California Environmental Quality Act, or CEQA, the scope of the certification, and the department's covered action determination. I will then briefly address the substantial evidence standard review and appellant's burden of proof. First, as to the preliminary injunction, as appellants have stated, earlier this year, a trial court issued a preliminary injunction. Oh, could we put the slides back up? I'm sorry. Yeah, thank you, this one. Issued a preliminary injunction prohibiting the department from proceeding with further geotechnical activities until it complied with the council's certification process. The department's intent in filing this certification is to comply with the court ruling so that DWR may proceed with further geotechnical activities. Appellants assert that this certification is inconsistent with the court's ruling. We believe this is incorrect. The question in the preliminary injunction ruling was if DWR was required to file a certification before it completed the geotechnical work. We believe it's up to this council to determine the proper scope pursuant to its statutory authority. The question before the court was not the scope at all. The ruling did not prohibit or even address the certification before this council today. And the decision by this council does not, as appellants have suggested, somehow overrule the trial court's determination. Rather, as I've stated, the council would be exercising its statutory role to determine the appeals before it. If appellants do not believe that the department's certification complies with the preliminary injunction ruling, each of these appellants are petitioners in that litigation, and they can file an action with the trial court in the future. Appellants' reliance on the trial court's preliminary injunction to conclude that the council lacks the authority to hear these appeals simply is incorrect. Second, as to CEQA, appellants improperly conflate the Delta Reform Act and the California Environmental Quality Act. The Delta Reform Act and CEQA are separate statutory schemes with separate objectives and procedures. Appellants urge that the Delta Reform Act requires this council to always treat a covered action to mirror the project description in a certified environmental impact report. The Delta Reform Act includes no such requirement. This council is an independent agency governed by its own authorizing act, regulations, and procedures. The CEQA statutes, regulations, and case law are not controlling on the council's interpretation of the Delta Reform Act. Now, appellants are correct that the Delta Reform Act, in defining a covered action in Water Code section 85057.5, references Public Resources Code section 21065's definition of a project. Appellants suggest that by referencing Public Resources Code section 21065, the Delta Reform Act has incorporated CEQA's piecemealing provisions. This is incorrect. Public Resources Code section 21065 does not reference piecemealing or a whole of the action requirement. Those provisions are set forth in separate CEQA statutory and regulatory provisions, as well as case law interpreting the whole of CEQA's requirements, not the Delta Reform Act's requirements. The plain language of Public Resources Code section 21065 simply asks whether a public agency action has the potential to result in a direct or reasonably foreseeable indirect effect on the environment. The geotechnical activities before you today indisputably meet that definition because they are a government agency action and they have the potential to result in a direct or reasonably foreseeable indirect effect on the environment. Therefore, the Delta Reform Act's reference to Public Resources Code section 21065 does not somehow render this certification improper. Third, as to the scope of the certification, to determine the proper scope, we believe the council should look to the Delta Reform Act and the council's own regulations, procedures, and guidelines. The Delta Reform Act does not include a requirement that related proposed actions must always be evaluated in a single certification of consistency. The purpose of the certification requirement is to ensure that a proposed action is consistent with the Delta Plan. Here, the department certified the Delta Conveyance Project EIR and selected the Bethany Reservoir Alignment Alternative as the project in December of 2023. This allowed the department to focus its available funding and resources on further evaluating and designing the Bethany Reservoir alignment. As Mr. Finney mentioned earlier, currently the Bethany Reservoir alignment is at approximately a 10% level of design, and the subsurface elements of the project are at approximately a 2% level of design. This, as explained in the certification, means that the project remains at a conceptual level of design. Requiring an agency to file a certification at this early level of design is not required by the Delta Reform Act or the council's regulations and would not promote informed decision-making. The geotechnical activities are temporary activities for data collection purposes only. When the work is completed, the sites are returned to their original condition. The work does not legally or practically compel completion of the Delta Conveyance Project. Rather, the activity's purpose is to identify the conditions of the soil, to validate, and if needed, modify the design of the project as well as the layout of the project. This information will in turn inform future decision-making by the department and other responsible agencies on approvals and funding decisions required for the project. The council's own covered action checklist recommends that an agency file a certification of consistency after the design and operations of a project are finalized. This recommendation makes sense to ensure that a certification considers the true scope of a covered action and its consistency with the council's regulatory policies. The council's own Delta Plan Program EIR also recommends that agencies conduct geotechnical activities during the design of projects at and near the locations of facilities to the depths necessary to characterize subsurface conditions. That's at page 11-41 of the council's Delta Plan Program EIR. Interpreting the Delta Reform Act to prohibit such data collection before certification of an infrastructure project would limit the ability of agencies to gather information recommended in the Delta Plan Program EIR prior to certification. Such a limitation is not consistent, nor would it advance the objectives of the Delta Reform Act. Now, appellants have suggested that the fact that the certification only includes a subset of the planning and design geotechnical activities contemplated in the Delta Conveyance Project EIR demonstrates that the certification is improper. The exact opposite is true. DWR did not approve the geotechnical activities in order to complete all of the geotechnical activities required for the Delta Conveyance Project. Rather, the purpose of the geotechnical activities is to advance future informed decision-making on the project. For this reason, the department developed the 2024 through 2026 proposed geotechnical activities specifically in consideration of areas in the Delta where the least amount of existing information is available on subsurface conditions, as well as based on where further data collection is anticipated to most likely lead to modifications to the project design, alignment, or layout. The narrow purpose of the geotechnical activities confirms that they do not legally or practically presume completion of the Delta Conveyance Project. For all these reasons, interpreting the Delta Reform Act in the manner that appellants urge to prohibit data collection activities after certification of an EIR would simply limit the information that may be available to this council during future certification appeals, both for the Delta Conveyance Project and for all other future projects that come before this council. That would not advance informed decision-making or the objectives of the Delta Reform Act. Therefore, the department respectfully requests that the council reject appellant's argument that this geotechnical certification cannot be filed before a certification on the Delta Conveyance Project. Fourth, as to DWR's covered action determination, appellants have argued that the certification should be rejected because the department concluded that the geotechnical activities are not a covered action. Now, while it is true that the certification includes substantial evidence supporting the conclusion that the geotechnical activities are not a covered action, to be conservative, the department also evaluated the geotechnical activities as a covered action in the certification. And in their appeals, appellants urge that the geotechnical activities are inconsistent with several of the council's regulatory policies. If appellants' arguments had merit, that would mean that the geotechnical activities are a covered action and that the department's certification is inadequate. Therefore, to resolve the appeals, the council necessarily needs to determine whether the department's certification is supported by substantial evidence in the record, and we respectfully request that the council issued a detailed opinion addressing each of appellant's arguments. Can you turn the page, please? Next slide. Oh, sorry, thank you. So we just want to briefly, I know we got time, okay. Touch upon the appellant's burden of proof and the substantial evidence standard review because it is such an important issue to this proceeding. The Delta Reform Act directs that the appellant has the burden to show that the certification is not supported by substantial evidence in the record. The council in prior appeal determinations has explained that substantial evidence means enough reasonable information and reasonable inferences that a fair argument can be made to support an agency's determination, even though other conclusions can be reached. To meet this burden, that means that the appellants needed to identify all the evidence in the record supporting the department's determination and demonstrate that no reasonable person could have reached the conclusion reached by the department based on the evidence before it. Appellants have not met this burden. Much of appellants' arguments are based on speculation of what could happen if the geotechnical activities are not completed consistent with the procedures and mitigation measures that the department has committed to comply with. Speculation is not evidence, and these arguments should be rejected. Even where appellants have identified evidence and suggested that another conclusion would be equally or more likely than the one reached by the department, this too fails under the substantial evidence standard review, because as the council has explained in prior determinations, the council does not weigh conflicting evidence and decide who has the better argument. In short, the council should deny the appeals because the appellants have not demonstrated that no substantial evidence in the record supports the agency's certification. With that, I'll pass things over to Ms. Marquez to address their substantive policy consistency arguments.
Hi, I'm Catherine Marquez. As Carrie mentioned, I'm a program manager in the Delta Conveyance Office for DWR. I have been working on environmental planning for Delta Conveyance for the last 8 years and working on environmental planning for the department for the last 16 years. I'm going to discuss policy-specific appeals, but I did want to note that appellants did not meet their burden to identify all the evidence relied on by DWR and to demonstrate that based on that evidence, no fair argument supports DWR's policy consistency determination as to the specific Delta Plan policy being appealed. I'm going to start my discussion with the co-equal goals. So one of the steps in evaluating if a certification is required is determining if the proposed activities would have a significant impact on the achievement of the co-equal goals. No individual proposed action is expected to achieve the co-equal goals by itself, and any speculation by appellants on general potential impacts is not substantial evidence. Additionally, covered actions are not required to contribute to the achievement of the co-equal goals, but being consistent with the co-equal goals means not impeding progress on the achievement of those goals, which the proposed activities will not. Appellants argue that by citing activities within connectivity areas mapped in the Delta Conveyance Project Final Environmental Impact Report, or EIR, a substantial effect on terrestrial wildlife connectivity and movement would occur, and therefore a substantial effect on the co-equal goal of protecting, restoring, and enhancing the Delta ecosystem would result. However, the wildlife connectivity maps in the final EIR depict large areas of habitat for a broad range of species to help prioritize conservation, mitigation, and other land-based decisions, and were not intended to be areas of direct avoidance of any activities. Not all activities within a wildlife connectivity corridor are considered to significantly impact movement of wildlife in the area. As Mr. Finney explained, the work area for each individual geotechnical activity is small and the duration is short. That, with the implementation of avoidance measures for special status species, support that these activities would not result in a significant barrier to wildlife movement, nor have a substantial effect on the co-equal goal of protection, restoring, and enhancing the Delta ecosystem. So next, I'll talk about ERP 5. This policy covers a proposed action that has the reasonable probability of introducing or improving habitat conditions for non-native invasive species. Proposed actions that are subject to this policy must fully consider and avoid or mitigate new introductions or improved habitat conditions for non-native invasive species, the striped bass, or bass. South Delta Water Agency argues that the potential for new introductions or improved habitat conditions for non-native invasive species is not fully considered and mitigated to appropriately protect the ecosystem because DWR has only committed to clean equipment and not vehicles or clothing. To clarify, vehicles are included in the description of equipment in the Delta Conveyance Project Final EIR and thus are included in the measure. Appellants merely speculate that clothing of visitors in the Delta may create reasonable probability of introducing or improving habitat conditions for non-native invasive species. Speculation is not substantial evidence. If the need to access sites within the Delta created a reasonable probability of introducing or improving habitat conditions for non-native invasive species from clothing, then all Delta tourism and virtually all activities proposed within the Delta would implicate this policy. Furthermore, even if the requirement to access sites within the Delta could be viewed as implicating this policy, through implementing practices related to siting, restoration of sites, surveys, monitoring, and training, DWR has found no evidence, and appellants have not identified any evidence, that previous geotechnical work has led to any new introductions or improved habitat for non-native invasive species. Thus, substantial evidence supports the conclusion that practices used ensure that activities do not have a reasonable probability of introducing or improving habitat conditions for non-native invasive species, and therefore, ERP 5 is not applicable to the proposed geotechnical activities. Moving on to Delta Plan Policy DPP2. This policy covers proposed actions that involve the siting of water management facilities, ecosystem restoration, and flood management infrastructure. Proposed actions that are subject to this policy must site facilities to avoid conflicts with existing uses. The data collected from these geotechnical activities will inform siting of facilities, but inform is not the same as involve. The borings themselves are not water management facilities, nor will they be part of those future facilities, thus will not involve the siting. Additionally, the collection of data at a given location does not commit DWR to site facilities in that location. In fact, data collection may result in the need to adjust the location of that facility during the design process. Even if this policy were implicated, citing of geotechnical investigations is conducted with avoidance of sensitive resources in mind and reducing any potential conflicts with ongoing agricultural practices, including that activities are generally cited on agricultural farm roads or regularly used agricultural staging areas. Unless otherwise authorized by an owner, sites are more than 100 feet from all residences and small business operations. There would be no removal of any vegetation without landowner approval and necessary biological surveys. Work would occur weekdays from 7 a.m. to 7 p.m., excluding specified holiday periods, and will not occur between September 1st and October 1st on vineyards or other planted land, or between October 1st and February 25th on hunting land. Activities that occur on agricultural lands would be grouted from the full depth to 5 feet below the surface, with the final 5 feet being backfilled with topsoil, returning the site to pre-project conditions. And DWR are committed to comply with any rules or regulations of a reclamation district applicable to the underlying property owner. For example, regarding weight of vehicles on its easement area, or restricted access to pumping stations, or digging near levees. And coordinating with local maintaining agencies when within 300 feet of a landside levee toe. In the proposed project, only in the proposed geotechnical activities, only 4 of the geotechnical activities are proposed between 50 and 200 feet of a levee toe, and 5 are proposed between 200 and 300 feet of the toe of a levee. Geotechnical activities have no incompatibilities with land use plans, policies, or designations, nor would activities result in the permanent conversion of land to another use. County of Sacramento et al. References a harvest water program technical memo that was prepared after the certification was filed, which we objected to as extra record evidence. The memo raises biological resource and traffic concerns, but does not explain how these concerns result in a land use conflict between the proposed geotechnical activities and the harvest water program, or that based on evidence in DWR's record, no fair argument supports DWR's policy consistency determination regarding the applicability of DPP2. Additionally, when the certification was submitted, the harvest water program was neither fully constructed nor operational, and the proposed geotechnical activities are planned to be completed before the program is operational. As discussed in the CEQA memo, with implementation of environmental commitments and mitigation measures, the proposed activities will not result in significant impacts to biological resources. There are no significant traffic impacts because the proposed activities will not have full road closures or unreasonably block access by other vehicles on levee roads or other reclamation district operated roadways. The proposed activities will avoid potential conflicts with community events or festivals through implementation of EC 18. All appropriate permits for geotechnical activities have been and will continue to be obtained, and safety measures abided by. Additionally, to minimize temporary disturbances, all project-related vehicle traffic and material storage will be restricted to established and/or designated ingress and egress points, construction areas, and other designated staging storage areas. These areas will also be included in pre-construction surveys and, to the extent possible, will be established in locations disturbed by previous activities. DWR has held several coordination meetings with Sac Sewer regarding the Delta Conveyance Project actions within the Harvest Water Program area and is committed to continuing to discuss Sac Sewer's perceived conflicts going forward. Additionally, the alleged failure of DWR to implement Delta Plan mitigation measures 7-2, 8-1, and 17-1 is not in itself a DPP2 conflict with existing use and there is substantial evidence in our record supporting the determination that the listed Delta Plan mitigation measures are not applicable. Appellants have not shown that based on evidence in DWR's record, no fair argument supports DWR's consistency determination that DPP2 does not apply. And even if it did apply, no conflict with existing uses exists. Next slide, please. So moving on to mitigation measures. This is Delta Plan Policy GP1B2. The Delta Plan Programmatic EIR evaluates the potential effects of the policies and recommendations of the Delta Plan, including an evaluation of a broad range of projects that could occur as a result of Delta Plan implementation. The Delta Plan and the proposed geotechnical activities have very different scopes and levels of effects on the environment that lead to different mitigation needs. The proposed geotechnical activities, environmental commitments, and mitigation measures are the same as, equal to, or more effective than the applicable measures identified in the Delta Plan Programmatic EIR. Appellants disagree, but often fail to identify specific applicable Delta Plan mitigation measures that were not addressed. Even when appellants cite specific Delta Plan measures, the appeals should be denied because, 1, Delta Plan Policy GP1B2 only requires an agency to implement Delta Plan Programmatic EIR mitigation measures or equivalent measures when the measures are applicable. 2, many of the Delta Plan Programmatic EIR impacts mentioned by the appellants do not have a corresponding potentially significant impact on the environment requiring mitigation related to the proposed geotechnical activities evaluated in the certification. And 3, appellants fail to articulate why the proposed geotechnical activities, environmental commitments, or mitigation measures are not equally or more effective than the related applicable feasible Delta Plan mitigation measures. With regards to Delta Plan Mitigation Measure 7-1 and 7-2, the proposed geotechnical activities will not result in a potentially significant impact regarding the conversion of farmland to non-agricultural use or conflicts with existing zoning for agricultural use of a Williamson Act contract on the environment requiring implementation of these Delta Plan mitigation measures. Therefore, Delta Plan mitigation measures 7-1 and 7-2 are not applicable. General concerns raised by appellants regarding potential impacts will not result in conversion of farmland to non-agricultural use or conflicts. Oh, it's not resulting in conversion of farmland to non-agricultural use or conflicts with existing zoning are not relevant to GP1B2 and Delta Plan mitigation measures 7-1 and 7-2. However, appellants raise concerns regarding impacts to agriculture, some of which were already discussed when I discussed DPP2, but also include concerns regarding the number of borings occurring at the same time and concerns regarding contamination of groundwater. The borings and the CPTs described would not all occur at the same time. The CEQA memo analysis assumed up to 1 to 2 CPT rigs and 4 to 6 drill rigs in operation at the same time based on the number and location of proposed activities in each county, equipment and staffing constraints. And then as mentioned by Mr. Finney, the cement bentonite grout provides borehole stability and prevents groundwater contamination. Appellants have failed to demonstrate that based on evidence in DWR's record, no fair argument supports DWR's policy determination that Delta Plan mitigation measures 7-1 and 7-2 are not applicable. With regards to Delta Plan mitigation measure 4-2, the project description for the proposed geotechnical activities in the CEQA memo incorporates and the analysis evaluates applicable mitigation measures set forth in the Delta Conveyance Project final EIR, as well as applicable best management practices and environmental commitments, including the EC14 plan and associated soil investigation, initial study, mitigated negative declaration, mitigation measure commitments. This document is enforceable as an activity-specific plan required by the Delta Conveyance Project final EIR. One such commitment is that if the biologists identify the potential for special status wildlife impacts during surveys, The location will be shifted to a suitable location as identified by the qualified team of biologists, which is defined as a location that achieves the following performance measures. 1 is the minimum distance necessary, informed by species-specific mitigation measures to ensure that no special status plants and wildlife with the potential to occur is disturbed during the work activities. 2 does not increase impacts to other resources above a level of significance. And so with that in mind, I'll remind you guys that an archaeologist and a tribal monitor are also part of that survey crew. And 3, the qualified biologist team must determine that commencing activities does not have the possibility to cause unpermitted take under federal or state law. If through redesigning or relocating proposed sites for geotechnical activities, potential for special status wildlife impacts cannot be avoided, then the proposed activity will not move forward. DWR's commitment to abandon sites where potential special status wildlife activities cannot be avoided, wildlife impacts cannot be avoided, exceeds Delta Plan Mitigation Measures, Measure 4-2's requirement to avoid impacts to the maximum extent practicable. Appellants have failed to demonstrate that based on evidence in DWR's record, no fair argument supports DWR's policy determination that implementation of Delta Conveyance Project environmental commitments and mitigation measures are the same as, equal to, or more effective than Delta Plan Mitigation Measure 4-2. Lastly, I'm going to talk about best available science. This is Delta Plan Policy GP1B3. In addition to meeting industry standards by following the standards set forth in State of California Bulletin 74-81 and 74-90 and local county standards, the 2024-2026 proposed geotechnical activities are informed by lessons learned from past geotechnical investigations and methods used for sealing geotechnical investigations as outlined in the project-specific field exploration standards. DWR has committed to comply with any general rules or regulations of a reclamation district applicable to the underlying property owner. Compliance with these standards and rules and lessons learned from prior geotechnical activities ensures that the 2024-2026 proposed geotechnical activities are informed by best scientific information and data. San Joaquin County et al. Requested to add a technical memo from ENGEO. While we object to the extra record evidence because it was prepared after the certification was submitted, we do want to note that it states, in our opinion, geotechnical explorations can safely be performed in the Sacramento-San Joaquin River Delta without creating substantive flood control and other risks, provided that both the exploration and exploration abandonment guidelines in reference 1 are followed. Reference 1 is DWR's California Well Standards Bulletin 74-90. Bulletin 74-90 is the guideline that DWR has complied with and will continue to comply with in undertaking geotechnical investigations for the Delta Conveyance Project. Appellants have advanced speculation regarding potential impacts that could occur if DWR did not comply with Bulletin 74-90. Not only is speculation not evidence, appellants have failed to provide any evidence to suggest that compliance with Bulletin 74-90 is not consistent with the best available science policy. Lastly, I just wanted to add that while our presentation was not focused on tribal considerations because they aren't covered by any of the policies of the Delta Plan, we do agree with appellants on the importance of those issues, and we are committed to thorough tribal consultation through our CEQA process, and in our mitigation measures have committed to continued consultation on the development of mitigation and avoidance of resources. Also, I wanted to mention, as we talked about those site clearance surveys, tribal monitors are present during those surveys. And if a concern is identified, that is one of the reasons why we would adjust a site in the field. With that, I'll turn it over to Chris for closing comments.
Thank you. In conclusion, the 2024 through 2026 proposed geotechnical activities align with the Delta Plan's core policies, which prioritize best available science and adaptive management strategies. By gathering detailed site-specific data, the department is taking responsible, science-driven approach to planning and design to inform future decision-making on the project. While it's not entirely clear to the department what appellant's argument actually is with respect to if and when the geotechnical activities could move forward, it seems that they're either arguing that if we did these geotechnical activities before we certified the EIR, they would be proper, or that no geotechnical activities could move forward until after we completed a certification. Either way, we believe their argument is arbitrary and would severely limit the data that's available to this council in future decision-making, both on the Delta Conveyance Project and all other future projects. The department asks that the council find that substantial evidence supports the department's certification on all of the challenged issues and to deny the appeals. With that, we'd like to thank the council for its leadership and thank staff for all its hard work putting together this proceeding. We look forward to a decision on the appeals, and that concludes our presentation. Thank you.
Thank you all very much. All right, I'll ask council members if they have any questions for DWR. Councilmember Hoysa?
Yeah, thank you. Mr. Finney, you mentioned you had quite a bit of experience working on projects of this nature, including projects in the Delta area. And I wanted to ask, well, this is a pretty big project, and it's probably more likely you haven't worked on a project like of this nature. But even then, has any process in those projects been different in the manner that which they were either studied, that went through EIR? Any of those projects that had to go through EIR and permitting, was it any different for those projects than this project?
In terms of the explorations and how those
Yeah, I think
explorations
I would-
evolved?
just in general, but I do want to get to the explorations and whether you're going about the explorations in a manner that's different in this project than the other ones or consistent.
I will say that in my 30 years of experience, the level of documentation, the level of planning, and the level of monitoring for all manner of environmental and cultural far exceeds anything I've seen anywhere else on any other project I've ever worked on. Recognizing though that this is a very large project, somewhat controversial understatement, right? So it does receive the scrutiny, and so there's a lot of documentation, like I said, planning. I have not in my career also had the subsurface exploration for a project been generally it's conducted to inform the environmental permitting process and is typically not as controversial itself. The idea that you need data to inform your decisions, and then moving forward, you obviously do phased explorations. You need a certain level of data to inform the environmental permitting process, a certain level to take it from conceptual to preliminary design, and then beyond that, you would take it to a final design level. So, yeah, it is different and more rigorous, I suppose, the documentation. And did I answer your question? Or
yeah, just generally, did you? You made already a statement. You had planned to go through the geotechnical process between 25 and 26. Maybe can you explain, is that normal? Is that given that, you don't own the land, you can't really just go in there and do all the geotechnical, but is that normal to go through that process?
Yes, and the level of design that Chris mentioned with the underground elements being at 2%, it's very important for the water contractors and other involved to have as much data to understand whether there's adequate conservatism in the conceptual design right now, and whether that extra data will help them make very informed decisions. And that data is not necessarily available at all the locations that we're looking at.
Is it possible that the data that you collect can drastically alter the design of the project in a way that would affect the current EIR?
I would say that the data to be collected does have the ability, I wouldn't say drastically, but it might have the ability, it might drive decisions on ground improvement. To the extent practicable, we've moved the project outside the limits of the delta, maybe not the legal delta, but the delta when it comes to very soft marshy soils, which get thicker and thicker as you go west into the center of the delta. But the degree to which ground improvement is required, the cost and the environmental impacts of this, the truck traffic, the air emissions, all that, they all have the ability to be affected by that. And so it's important that if that is discovered, that it's discovered early and mitigated through various measures that we have available to us. But yeah, it does have the ability, the presence of abandoned gas wells, for instance, has the ability to result in again, we've done the due diligence that's available to us now, but we need more data to make sure that we don't need to avoid an improperly abandoned gas
Is there
well.
a chance you can strike oil?
I hope not.
Is that possible?
No, not at the depths we're looking at. The gas down there is a mile plus below the delta. So,
okay. The other question I have is regarding the process, and that's been brought up, this process, and it concerns me because I think government should be transparent. It should be easy to follow. It should be applicants should have a very clear process in terms of how to move forward. It troubles me that sometimes the processes are so complicated that people get bogged down in the details, and it shouldn't be that way. So just generally, in this process itself, a decision was made by the judge that has been agreed to by both parties. Was there some level of consultation with the judge? Was there some consultation with staff at the Delta Stewardship Council to really understand what the rules are and what the process is? And is there some, is the judge in agreement that the process that has been required is the right one that should be followed?
Yeah, there isn't an opportunity to ask those questions to the court at this time, but I think it's important to emphasize that the ruling we've been talking about today is a preliminary injunction ruling. That is not a ruling on the merits. The court was asking whether there was a reasonable likelihood of prevailing on the issue of the activities constituting implementation of the project. And based on that, the court issued a preliminary injunction. The court did not hold definitively that it would be implementing the project to move forward with the geotech. The court did not in any way address the scope of the certification required. And if we asked that question to the court, I'm pretty sure the court's answer would have been the council decides the scope of the certification, not the court.
And did you consult with the council staff?
Yes, we had early consultation. I don't know if you'd like to.
So yes, in our certification, we did describe that we had early consultation with council staff on this project, which is described in the Delta Reform Act itself. It gives the council the burden of developing early consultation procedures.
Okay. And I imagine you made a decision based on that, or came up with a legal opinion. That's your legal opinion, that we're going through the right process.
Yes, we absolutely believe so. We think that if the council interpreted the Delta Reform Act differently, it would present a problem to the entire process, because the council should have data before them on a project when it makes its decisions. And the Delta Reform Act says that on remand, if the council decides the certification is inadequate, that an agency still cannot implement the project. So if these data collection activities or data collection activities for any project were considered part of the covered action and therefore could not proceed in advance, this council would not be able to direct that on remand that agencies do these type of activities. So it would create a quagmire that limited this council's discretion and does not make any legal or practical sense.
Native American resources were brought up also as an issue, and it was kind of inferred that you are privy to locations of sacred sites or important cultural artifacts. Is that being considered in the boring locations or in the project alignment or anything else that affects this project?
So I'd like to start off by saying that there is confidentiality requirements regarding government to government consultation with tribes. So there is confidential information that tribes have shared with DWR. That information is taken under consideration for the entire project, including these geotechnical activities. And the geotechnical activities are cited to avoid any known sites. So that is part of the consideration of citing those activities. And then, as I mentioned before, in addition to that, we do have that ground truthing site clearance survey, which we do coordinate with tribes on. And if there are tribal concerns that are brought up during those site clearance surveys, we adjust the site to avoid those resources, or we can choose not to do those geotechnical borings at that time.
Okay. All right, thank you. Those are all my questions.
Any other members? Yes, Councilmember. I have one. Moranian, and then I'll go to you, Councilmember
Thank you.
Burgess.
Mr. Finney, you were very comprehensive in explaining that, you know, a lot of mitigation measure was done during this period and outreach to the community and all that. And I appreciate that. And my question is, when we do EIRs, especially EIRs of the size for this project, we have a geotech section, right? And how much of this, not specifically, but this kind of activity was mentioned in there? And yeah, first that, and then I have another question.
Do you want me to answer that one?
I'll do a first pass and then hand it over to you.
And then I
wanna
have one more.
Stay in my, I want to stay in my lane. Well, one of the first things that we did as the DCDCA was, I mean, our goal was to obtain as much relevant geotechnical subsurface data for the entire Delta, 5-6 years ago, to support the preparation of the EIR. And the first step was to go out and consult with agencies, private entities, pipeline operators, transmission tower owners, other agencies like East Bay Mud, and gather all of the available subsurface data into one database that is generally considered, some of it's confidential because we've had to sign non-disclosure agreements, but the idea was to minimize the amount of actual data collection that we needed to do and to maximize the understanding of the Delta for the preparation of that. So then we supplemented those data with our own explorations, the 200 or so that I mentioned that were prepared in preparation. And they absolutely informed the decisions and the analyses that are contained in the EIR. And at that point, after the word EIR, I have to turn it over to.
Sorry, so I just want to clarify the question. So you were asking how much of the proposed geotechnical activities were described in the EIR, or how much of the information informed the EIR?
I understand a project of this size has layers of, let's say, when we say geotech, and how much originally we know and how much later we learn. And I mean, it's very layered. Plus you have changing, geomorphology. I mean, things change over time and you need to redo stuff. But my question is, how much of it was known and how much of the process you already knew about, which is already in the EIR? That's my question.
Yes, so the activities that we're proposing right now were described in the EIR. So that how we are doing the work, what we're doing is described in the EIR. It is a subset of the total field investigation activities that were proposed in the EIR. So as was mentioned before. So we did take a conservative approach of everything that we would need in order to complete the project. And this is a subset of those activities in order to reach a percentage of design to support some of the decision-making that needs to happen.
And the mitigation measures, the way it's done now, was also mentioned in the EIR.
Yes, so the mitigation measures obviously are for the entire Delta Conveyance project. So there are some mitigation measures in the EIR that are not applicable to the specific geotechnical activities. So there is a little bit of discussion that needs to happen to explain that connection. And then there is a commitment in the EIR. It's an environmental commitment, EC 14, that requires us to develop a compliance monitoring plan and includes the addition of additional commitments, site-specific or activity-specific commitments. And so in that EC 14 plan, there are additional, very specific to the geotech commitments that were added to the EC 14 plan and to the overall compliance parameters that we need to follow in order to do these.
Yeah, and that was my question, that the geotech part had certain kind of mitigation measures that have been observed in this.
Yes.
You answered my question. Thank you.
Thank you.
Thank you. Councilmember Burgess.
Thank you. It was really interesting to see Director Nemeth. We go back 20 years ago. I was running Friends of Marsh Creek, and I invited somebody from DWR to come speak about the iteration of what it was at that time. And she came out to Brentwood. And so it was kind of interesting to see her and to kind of reflect on here we are, you know. She opened up saying this project is important to the state of California, indicating that we're talking about conveyance. And so then I hear everybody talking about the whole versus the part. And so it's kind of interesting because I'm trying to come in here listening, and it seems as if what we're looking at is that small part. That's what we're being asked to, but it's being discussed in the context of the bigger project. And so it's hard to separate those things when we're not really considering the bigger part. So I have a couple questions. Mr. Finney, is the exploration of activities that we're talking about, have those been done in the Delta before, and have they required us to consider those for consistency?
They have been completed. Yeah, so we've completed roughly 188 explorations to date to support the development of the EIR across the entire Delta. And I do not believe they were, I'll let Catherine talk to.
So what Mr. Finney is referring to is what was known as the soil investigations for data collection in the Delta project.
You remember that?
Yeah, I remember. And it was, our CEQA document was an initial study, mitigated negative declaration. So that was an evaluation of just a set of geotechnical investigations. That particular effort was looking at multiple alignments. So looking for filling data gaps along multiple alignments in order to inform decision-making for the Delta Conveyance Project EIR. So that work, we filled out a covered actions checklist. We determined that it was not a covered action and did not file a certification of consistency for that effort. Again, we did consult with the Stewardship Council staff in that effort as well.
And in the slides, you said the subset will not include work on levees, overwater activities, activities that involve trenching, or permanent facilities. Are all those things that would be put into the covered actions in the future for the whole, or are we looking at kind of coming back with these kind of things in the future? Or do you say that's a good question?
We intend to bring back the Delta Conveyance project as a whole. with activities included as part of that project in the future.
And so, Mr. Butcher, you said this is a limited scope of the project, and you've heard everybody talking about the whole and the piece. And I think a lot of it goes to referencing the CEQA definitions of the project. Do you want to address that?
Sure. I mean, as we explained, we don't think that a reference to Public Resources Code, section 21065 in Water Code, section 85057.5 incorporated all of CEQA's piecemealing concepts. But as we did explain in our written submission, even under CEQA, we don't believe that this is improper piecemealing. Just because activities are related to one another does not mean it's piecemealing to separate them. Courts have said, for example, that where an activity is only a baby step towards a bigger project in the context of CEQA, that's not improper piecemealing. Courts have held up doing a segment of a highway when funding was only available for part of a bigger highway project at the time. Again, here, I think it's clear that these geotechnical activities are at most a baby step, and we do not have funding to construct the project. In fact, the Delta Reform Act says that we can't move forward with the project until we have funding from the state water contractors. So here, as in that highway example, we have funding to do this limited set of work. There's another recent CEQA case where a court said after you certified an EIR like we've done here, you can then move forward with the project in phases. That's not piecemealing once you've completed your EIR. And then finally, earlier this year, the 3rd District Court of Appeal addressed this very question on the Delta Conveyance Project. There was a lawsuit filed over long-term water contracts that the department approved. And petitioners argued that because those contracts were a necessary step in funding the Delta Conveyance Project, it meant that we improperly piecemealed those actions from the project. And the court said that even if we assumed it was a necessary step, it was, and I quote, a distant step towards several other hurdles facing the project. Here, as you are aware, including what the Delta Reform Act requires, like the public agency funding, the CPOD change of point of diversions, approval from the Water Board, there are a long list of approvals still required for this project. We are still very much, not only in the planning sense, but in the approval sense at the early stages. And so it is a distant step. And so just like the 3rd District Court of Appeal ruled earlier this year, even under CEQA's concept, we don't believe this would be improper piecemealing.
I'm fascinated by the whole timing of all of the different processes that have to happen. You know, it seems like this should happen before this, and I know that we talk about that. So originally, you didn't see this as a covered action, and so you're now having to present it as a covered action, and then say why the various appeals, why you are still consistent with the Delta plan. It's an awkward place to be.
I won't deny that, but yeah, yes, our written submission, what we attempted to do is present the evidence for why we didn't believe the geotechnical activities implicate the various regulatory policies, but the ones where we acknowledged perhaps alternative arguments could be made, we also addressed why we were consistent with those policies. For example, with ERP5 and DPP2, as Ms. Marquez addressed in the presentation.
Yeah, and I think you said to be conservative, you've packaged this up to make, to try to make this happen. I will say, I appreciate Ms. Marquez, you going over all the different items. The Harvest Water Program, I mean, I will just want to put on the record that the timing of how everything was done has been really challenging for everybody involved. And I think, even like with the Delta Protection Commission, the timing of their meeting to be able to do a comment, I mean, it just makes it difficult, making it difficult for, people to do their appeals properly and all that. And there can be an impression that that's on purpose. So I just want to point that out, that it's really appreciated when folks can do their jobs and not have to try to make it work. Jorge, were we involved in any of this as far as were we consulted related to this?
You mean the timing for the briefs?
No, the injunction and all of that.
No, we're not. We are not a party to that.
Okay.
And I'll point out that, it'd be great if the legislature would give us more time, but we have 60 days to get through this process from start to finish.
Okay. So yeah, I just wanted to point that out. Thank you.
Right. Any other questions from members? Okay, thank you, department folks. I think at that time, this concludes our presentations, and I'll ask the members if they have any final questions for any of the parties at this point before we move on to public comment. Nope.
I have a process question. So we're hearing from everybody. Is this the last time we'll hear from them in our hearings?
So do you want?
Sure, I can answer. So we have the legislature gives us 60 days to have a hearing.
Mhm.
We've had the hearing. After today's hearing, we'd have 60 days to make a decision.
Okay.
So this is not something that council voted on, can change. It would take an act of legislature to do something about it.
So this is our last chance to ask questions of all involved.
Correct.
Okay.
All right. So now what we're going to do is want to talk a little bit about a break coming up. I think our staff and court reporter are going to need a break around 1:30. So I'd like to go ahead and push through and get in a few of the public commenters that are here in person. I know we have a number of people that have submitted blue cards. So let's kick that off, and we'll ask people to be concise in their comments to help us kind of get through this. So please remember that we're here today to receive comments on the geotech appeals, and please keep that in mind when providing your comments today. As I mentioned earlier, the scope of the council's review is limited to whether or not the certificate of consistency was supported by substantial evidence in the record before DWR. Emma, can you let me know how many commenters we have for this agenda item?
We currently have 9 requests for comment.
Thank you. So we're going to ask the public to limit your comments to 2 to 3 minutes, please. And Emma, who is our first public commenter?
Our first public commenter is Crystal Moreno, a representative of the Shingle Springs Band of Miwok Indians.
Can you guys hear me? Ooh, wow. It's loud. Can I turn it off?
Yeah. Yeah, feel free to have a seat. Our folks online won't be able to hear us unless we're using a microphone.
Okay. Is better? Okay. Thank you. Hello, everyone. I rushed in here today because I was listening online, and I just have so much emotion right now based on what I've been hearing. Came here in person because I want to make sure that you understand how this impacts tribal communities. I've listened to the discussion around whether or not consultation with tribes is required under the Delta Plan. We run into these questions, and to me, it's a no-brainer. Sometimes there are laws or policies that are made that just don't consider tribes because we just weren't there and we weren't thought of. And others around the table making these decisions never said, where are the tribes? How do we consider them? How does this impact them? This is something we're still dealing with. So even though we have executive orders and we have laws like AB 52 consultation, which requires consultation early and often with tribes, it still doesn't occur. And people try to find their ways around it. We need to ask ourselves why that is. We are going to be severely impacted by this entirety of the project, including the geotechnical drillings. And here's what is upsetting to me. DWR is well aware that cultural resources, including human remains, have already been found. There was a site visit that was done in the Delta near the town of Hood, and conveniently, we were left out. We were not included in the notice. They chalked it up to a mistake. They chalked it up to some type of error in email lists, and it's just unacceptable. We were told by another tribe that was on site that day about the cultural resources, and then DWR later confirmed human remains were found. And these aren't just specimens to us. These are ancestors. We've been saying it, we'll continue to say it. Even though, I've heard the geotechnical drillings limited, severely limited to small impacts. It's not true. Cultural resources have been found on the surface, if not just below the surface already. That will continue to happen. You talk about mitigation, right? Mitigation and avoidance. We have not seen that yet. The department knows this. It's so difficult to sit in this audience today and to listen to what I believe are just outright lies, whether that's spoken or by omittance, but they are very well aware of the cultural sensitivity of the entire area. This is not a matter of when ancestors are disturbed, or of if. It is a matter of when, and in fact, it has already happened, as I already stated. Even if the Delta Stewardship Council does not feel that AB 52 applies, there is still an obligation under the California Civil Rights Code to consider tribes and impacts to us, our cultural resources, and our ancestors. I'm here today on behalf of the vice chair who could not be here. And I'm almost glad she wasn't here, because to have to listen to these things, to have to hear people try to justify not considering tribes and the impacts to our communities and our resources and our ancestors, it is heartbreaking, it is traumatizing, and I'm glad she's not in the room today. These are her ancestors. So when we want to talk about how you mitigate that, you cannot mitigate that. You cannot mitigate digging up the resting places of our people. We heard them talk about, well, the drill will go in, however many inches into the ground. But you didn't hear them talk about the disturbance that the vehicles create. You don't hear them talk about even people that are unaware who are walking on these sites, the disturbance that creates. This is happening. It's already happened in the field, the soil investigations, field studies. We had a tribal monitor out there. We're having to explain to people what they're looking at, what they're seeing. But again, when the human remains were found, conveniently, that was a site visit that we were not invited to. These are the things that we deal with every single day. This is a very deeply personal thing that impacts tribes on a spiritual level. There are things that I can't even fully convey to you all because it's just something that you feel. So when you're sitting here and you're making these considerations and you're listening to people tell you all the reasons that they didn't have to consider tribes, I'm here to tell you they should, they need to. You are obligated to consider us. And if that's not by law, then that's just by doing what's right. We are here. You have executive orders that talk about consultation with tribes. So whether or not anyone believes that you as the DSC have the obligation, to ensure that the department upholds their obligations to us, we believe that you do, and we believe that you should.
Thank you for your comments here today. We appreciate that. Emma, can you call our next commenter?
Our next commenter is, I'll be calling so our next commenter is John McHale, who is online.
Should we try to come back to him, Emma?
Yeah, we'll move on to our next public comment, which is Kyle Griffith.
Good afternoon. My name is Kyle Griffith. I'm speaking on behalf of Californians for Water Security. We're a broad statewide coalition of business, labor, social justice, and local governments formed in support of the Delta Conveyance Project. We appreciate the opportunity to comment during the hearing today on the ongoing proceedings. I want to start out by saying how important the Delta Conveyance Project is for the state of California and building resilience into the State Water Project. The State Water Project is relying on 60-year-old infrastructure in order to deliver water to more than 2/3 of Californians and is in desperate need of upgrades. The geotechnical investigations do not represent an implementation of the DCP, however, but are an exploratory activity designed to gather the data necessary to further refine the engineering and design of this project. These activities align with the Delta Plan's core policies, which prioritize the use of the best available science and adaptive management strategies. By gathering detailed site-specific data, DWR is taking a responsible, science-driven approach to planning, a hallmark of Delta Plan compliance. It's worth noting that the need for further geotechnical activities were disclosed in the Environmental Impact Report certified in December of 2023. These activities are neither new nor unexpected. They are a continuation of the work that has been underway for years. The appeals posed before the Delta Stewardship Council today are thinly veiled delay tactics designed to slow progress and drain resources and distract from the pressing need to modernize California's water infrastructure. We urge you to uphold the certification today. Thank you.
Thank you. Go ahead and proceed, Emma. I'll let you push through with doing folks in order without me calling out in between each one. Just you go ahead and handle the public commenters and just have them keep rolling along, and I won't intervene after everyone.
Awesome. Okay. We're going to go back to John Steele. You should be able to see him. We're going to move on and we'll keep trying Mr. McGill. So our next public commenter is Cynthia Cortez. You should be able to see her.
Hello, can you hear me?
Yes.
Good afternoon, council members. I would like to address the council's responsibility to uphold the law to protect tribes and EJ communities. There are requirements in statute for consultation under CEQA and for any general or specific plan amendment that impacts land use. The Office of Planning and Research has issued guidance to all state agencies on how to do it, or do just that. State Executive Order B-10-11, which has made it state policy for a decade and a half for all state agencies to engage in consultation with tribes on their policies and programs. To the extent that this concerns decisions subject to CEQA review, CEQA requires consultation under AB 52. Under AB 52, any project that has a potential for environmental impact must consider tribal cultural resources through early, often and timely consultations with all tribes whose ancestral territories are located within the area of potential effect. Consultation is for agencies to hear and adjust projects to the concerns of tribal nations and for the protection of tribal cultural resources. The Delta Stewardship Council must uphold the public trust doctrine. The Delta Reform Act explicitly invokes the public trust doctrine in determining California's water allocation. The public trust doctrine requires the state to hold designated resources for the benefit of the people. As council members, you were sworn in to uphold the California's Constitution, which includes the public trust doctrine. I would also like to point to California Government Code Section 11135, which prohibits discrimination by state agencies on the basis of race and ethnic group identification in operation or state-funded programs and activities. It does subject state agencies in California to discriminatory impact liability. The council's decision today will impact tribal and EJ communities. Thank you for the opportunity to comment today.
Thank you. Our next public commenter is Charlie. Online, so this is on to Chris Wilson. You should be able to see him.
Hello? Can you hear me? I'm sorry?
We can hear you. Please proceed.
Oh, thank you. I can hear you. Thank you. My name is Chris Wilson with the Los Angeles County Business Federation. On behalf of BizFed, we believe the geotechnical work in the Delta is critical to the continued study of the Delta Conveyance Project. This is not to assume that the studies and geotechnical investigations equal a green light to construct the Delta Conveyance Project, but rather these activities are intended to gather the data necessary to further refine engineering and design of the project. The proceedings today are an attempt to further delay this project, which delays are not just unnecessary, but costly. Nearly 2/3 of Californians rely on drinking water that comes from the Sierra snowpack. But the State Water Project, California's main water distribution system through the Delta, is outdated and must be modernized to ensure California can continue reliably delivering water to homes, farms, and businesses throughout the state. It is critical that we maintain momentum towards meeting key permitting deadlines. Thank you.
Thank you for your comment. We are now going to go back to John McHale.
Hello. Hello. Are you able to hear me?
We can hear you.
Awesome. I apologize for the earlier technical issues I was having. So my name is John McHale. I'm calling on behalf of the American Council of Engineering Companies of California. So I'd like to address just the importance of the geotechnical investigations taking place here. These activities they're not the beginning of construction on the Delta Conveyance Project, but are rather a crucial step in collecting information that will help us improve the engineering and the design of the project. As civil engineers, it's disappointing to see efforts aimed at slowing down this important work. Data collection analysis is fundamental to advancing the project's design and ensuring that decision makers and regulatory agencies have the comprehensive information that they need to make informed choices. Pausing these efforts not only creates unnecessary setbacks, but also results in increased costs. Staying on schedule is critical to meeting permitting milestones, which are key to the project's success. Thank you for your time and your consideration.
Thank you. Our next public commenter is Tanisha Herring. And you should be able to unmute now.
Hi, hello. My name is Tanisha Herring. I'm here on behalf of the California Hawaii NAACP. We do support the geotechnical work in the Delta, which is critical to studying the Delta Conveyance Project, or DCP. These investigations are not only the start of construction, but gather essential data to refine the project's design. Delaying this work is unnecessary and costly. The DCP prepares us for climate change by modernizing our water infrastructure to adapt to extreme weather patterns like prolonged droughts and intense storms. It enables water capture when abundant, securing supplies for future dry periods. This project supports disadvantaged communities by protecting access to safe, affordable drinking water. It's also cost-effective compared to alternatives like desalination or wastewater recycling. By advancing the DCP, we ensure reliable water delivery, protect critical infrastructure, and support well-paying union jobs. Let's keep moving forward. Thank you.
Thank you for your comment. Our next comment is from Dwayne Martin, who is in person.
Hello, thank you for your time. I'm the rancher and a resident near the area of Franklin and Twin Cities. I've been grazing the property there that's going to be the main drilling site at Franklin and Twin Cities for almost 20 years. Nobody from DWR has asked me how it's going to impact my business, the grazing of the livestock there through any of this process, or my right to enjoy my home and my ranch where I live. I don't think the drilling process is going to go on for just daylight hours. Seems to me it'd be 24/7. I've got to listen to that. I've got to deal with the impact of the traffic and everything that's going to go on there. Also, I've had to deal with the drilling on this property already. They come in and drill. They tore up the roads. They offered to fix them. But when time is of the essence in business, when it dried out, we got them done. I told them they could offer to pay me. They said, I can't pay you. You're the tenant. You're not the landlord. Nobody cares about me. They want to do some more drilling. I graze cattle from April 1 to Christmas, depending on Mother Nature. We irrigate from April 15th to October 15th. When are they going to do the drilling? Nobody's asked me how we're going to manage to do this. They're not going to do it during the winter, I would imagine. So am I going to have to stop irrigating? Am I going to have to stop grazing the livestock? Nobody's come and seen me about any of this. So when was their impact study done that they confronted me and talked to me? And I know that the landlord is against the drilling, so that we'll take a court order to get this done on that Nevin Ranch, which is owned by my landlord. So don't let DWR BS you that they do everything right. And the pictures they showed up on the screen, they were drilling on roads, not in the fields where the farmers work and do the work. They weren't showing that they were going to drill in an irrigated pasture. Am I going to have to dry this ranch up for the summer while they drill, or 2 summers? 40 holes is what I can figure out is going to be drilled on this ranch. So you're impacting my livelihood. 500 cows and calves run on that ranch all summer. What am I going to do with them? Set them on a shelf? That's all I've got to say. Thank you for your time.
Thank you for your public comment. Our next public comment is from Ivan Sinok.
Greetings, council members, and good afternoon. It's been a while since I've been in front of you. It was last year where I spoke to you about AB 52 and Executive Order B 1011, as well as other executive orders that have come from the Brown and Newsom administration. The geotechnical drilling is part of a larger CEQA project, and therefore must be consulted under tribal cultural resources. I am here as an ally and advocate for the tribe that spoke before us, as well as the other community members that have spoken before me. Archaeologists are not subject matter experts on tribal cultural resources, and that's actually defined under Assembly Bill 52. The best available research for tribal cultural resources have not been used in the issue before you. The only subject matter experts on tribal cultural resources, according to the federal government, the United Nations, and the state of California, are the tribal nations for and during consultation. Projects like this must consult the people around the project and the people at the stake of the project. The tribes, the EJ communities, everyone presented before you here today have spoken the exact same language. Please consult and consider the impacts of this part, chip, or drop of a larger project. Even if the council believes the ruling is not CEQA and follows DWR's argument, I would again like to point you to California Government Code section 11135, which prevents and prohibits discrimination on the basis of race, ethnicity, and group identity in operation or state-funded programs and activities. If and when there's discrimination impact liability, DC, I apologize, too many acronyms today. I also have a 2-month-old at home, so I'm running a little low. The DSC is opening itself to discriminatory impact through this decision-making and not using the best available science, the best available resources for tribal cultural resources, and failure to properly engage EJ and the community of the Delta. Thank you for your time today.
Thank you for your comment.
Emma, can I ask you a quick question?
Yeah.
I know I promised 1:30 and it's 1:37. So Where are we at in the queue?
We have one last public comment online.
Well, let's push through.
Amber McDowell, you should be able to speak now.
Hi, I'm Amber McDowell with the Sacramento County Farm Bureau. We were part of some of the outreach for the soil investigations about a year and a half ago. And we had some barriers with the DWR saying that it's specifically for the Delta Conveyance Project and that they weren't going to be on the roadways, but to be on the very side of it. And in fact, they were blocking the roads. It made it very difficult for our farmers to move equipment, and they would just say, well, work around the time frames. As soon as, our Delta farmers who have limited access of roads options have to get on the road, there's nowhere to pull off. And so some of these drillings do impact our operations with traffic and to be able to harvest. And then the harvest trucks, having produce in those trucks sitting in the sun waiting for detours or delays. It all impacts our businesses for our farmers in our area, and there's not very easy options to go around. The other part of it too is the Delta people, and I'm a resident of the Delta, we see these drillings as part of the project. You're starting construction. And so it makes it very difficult that it's just one little baby step and it's still not a guarantee, but continually over the past, under the different names, this project's been denied for this whole conveyance. And the reason it's been denied is it is not good for the Delta. It's going to crash our economy. It's going to disrupt the environment. There's a lot of impacts that the residents, the communities, the tribal members, and everybody in this area is going to be greatly impacted, if not crashed, just like Owens Valley. And so, having to go talk specifically about these drillings right now, I have to talk about the water diversion permit on another day. All these little bits make it very difficult for our voice as a Delta resident and our farmers in their area to be able to convey every single time how this is going to kill us off. And so it's very hard to keep having to come back and express our concerns and not be listened to. So we hope that this is really going to be kind of denied because this is part of a whole project. And as much as they keep trying to break it up, it is a bigger project that we have to look at the whole of whether this project is good for the Delta or not.
Thank you for your public comment. I see no other further requests to comment, Madam Chair.
Thank you. And I'll just ask one more time, is there any other further public comment in the room? All right. Seeing none, we'll close the public comment portion of the hearing. And I want to thank everyone that has been here today. Council members, do you have any concluding questions or comments? No, Daniel? Nope. Okay. So once again, I'd like to thank all of the parties who are here as well, the Delta Protection Commission and the members of the public who have contributed to this proceeding. The council has received valuable information from the parties and speakers that we heard from today, and I realize that much of the information is highly technical, so the council will take some time to give it proper consideration before making a decision on the appeals. In order to help the council consider the issues before it, at this time, I'd like to direct staff to prepare draft findings based on the materials submitted by the parties and take into consideration the comments received over the course of this hearing. The council will consider the draft determination and, as Jorge mentioned, make a final decision within 60 days of today's hearing. And I want to remind everyone that ex parte is still in effect until a final decision is issued. So with that, we can adjourn the hearing portion of our meeting. And I guess I'll just ask the members, we have a few other agenda items on our regular meeting schedule. I think we can get through them really quickly, but if you prefer a break, it sounds like pushing through is the prefer. Okay.
Daniel.
And Daniel's summing up. Okay. Okay, so thank you for everyone that attended on the hearing part and getting back to our regularly scheduled meeting. We are on agenda item number 5, which is for items for the public to comment on any topic that is not on the council's agenda. So any items on the agenda item need to be taken during that item, but if anyone has a public comment for something that wasn't on today's agenda, now is the time. Emma, do we have any commenters?
Just going to give them one moment. No, Madam Chair, there is no request for general public comment.
Okay, thanks, Emma. Our 5th agenda item is our consent calendar. We have one item, which is the adoption of the November 21st, 2024 meeting summaries. Members, do you see any need for discussion on this item?
Move to second.
All right. Motion for approval by Member Moranian, a second by Member Burgess. And we will, before we vote, I will ask if there's any public comments on the consent agenda.
There is no public comment, Madam Chair.
All right, thank you. So we will proceed with a roll call vote on that one.
Councilmember Burgess.
Yes.
Councilmember Damrell.
Yes.
Councilmember Waso.
Yes.
Councilmember Moranian.
Yes.
Vice Chair Miller.
Aye.
Councilmember Zingali.
Yes.
Chair Lee.
Yes.
The motion passes.
The motion passes. All right, our next agenda item, number 6, is the chair's report. I've spent most of my month working on prepping for the hearing, so I'm just going to turn it over to Councilmember Burgess, who has a couple of updates from the Delta Protection Commission.
Yeah, we had to have a special meeting in December since we didn't have a quorum. The new calendar was approved by the commission. There was a presentation from the Delta Protection Advisory Committee. I was elected to serve another 2-year term as the chair of the Delta Protection Commission, meaning I will be with you guys for the next 2 years.
Congratulations.
Thank you. We had an NHA advisory committee update. There's been a meeting in October and November. Chair Lee has been, were you in the November one?
I was in the October one.
Yeah. And the Delta Protection Commission appointed ex officio appointments, which included Chair Lee from the Delta Stewardship Council, someone from the East Bay Regional Park District, someone from the National Park Service, and the Delta Conservancy and the Suisun Resource Conservation District. And then there were DWR items related to geotech that I excused myself from. And I did also want to do a shout out to the Delta Stewardship Council Christmas party. It was pretty exceptional. Those people love what they do. They are so passionate, and it was really wonderful to spend some time with them. That's not a Delta Protection
And they
Commission,
look amazing
but
in ugly sweaters.
there was some really ugly sweaters, so very impressive.
Very. Thank you. Thank you so much. All right, agenda item number 7 is the executive officer's
Madam
report.
Chair.
Oh, yes.
Public comment.
I was so close to not screwing it up. All right, are there any public comments on the chair's report?
There are none, Madam Chair.
Thank you. All right, now I'll turn it over to Jessica.
Okay, thanks. I'm gonna make my comments brief. I just wanted to report that we have no new covered actions that have been filed since our last meeting, and we've sent no comment letters this month. Also, the outreach highlights report and active projects list are available in your packets and online, and please take a look at our Wicked related social media outreach, which got a lot of attention. And that's all I have. We don't have a legal update or a legislative update this month.
All right, any public comments on the executive officer's report?
There is no public comment, Madam Chair.
Righty. The last agenda item is preparation for the next council meeting, which will take place on January 23rd here at the CNRA building in Sacramento. So please look for our posted meeting notice for further information or updates. And with that, we are adjourned. Thank you. Thanks for all your help, you guys. Great job.
Happy holidays, Dan.